That the Registrars meeting is being broadcast and recorded by the Marshfield Community Media. And I believe that would be the speaker sound. So, is there any other person who is recording this public hearing that we are aware of? Seeing none or hearing none?
I am
And
online.
can you please identify yourself?
Christine Hill.
Thank you. The objectors and recall petitioners are advised that the votes will be taken by roll call vote, as we have any motions that be heard at that time. So, yes, and I am Walter Sterling, one of the registrars and acting chair at this time. We have another chair, registrar, that is online right now. Unfortunately, he could not attend in person, but he is attending through the video, and I'll let him introduce himself. Maybe not. Yeah. That would be David O'Reilly is the other registrar. And Dave?
Yeah, I could introduce myself. I'm Dave Kolar. I'm also one of the registrars here.
Okay.
Mr. Chair, thank you. Lauren Goldberg, Special Counsel, and with me is my colleague, Michael Dortenzio.
Good morning.
Definitely.
Attorney Robert Galvin, Town Council.
Nerese Casper, Town Clerk.
With the introductions and everything like that, the Pledge of Allegiance is in order for the next part of the meeting. I
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
You can have anyone who's going to give testimony.
Okay. Again, recognizing that this is an informal meeting, we're having to discuss the issues related to the recall, but we like at this time to swear in those that are going to be making any type of statements or participate in this. So, the objectors and the petitioners.
You guys all stand. Is Joe available?
He's in the hall. He's in the hall on the phone. We can do it when he comes back. So you can swear, the clerk can swear them in.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
The objectors in the recall petition is representative of all particular. There may be two other witnesses, and we'll administer the oath to them when they appear.
Thank you for all showing up. Again, this is an informal meeting that we're going to go through the discussions, and we ask for respect for everybody that's participating in this meeting. And at this time, I'd like to ask counsel to give an overview of the issues, because there's a lot of legal issues associated with this, or implied or applicable. And with that.
Certainly, Mr. Chair, through you. The first thing that we were planning to address today were the preliminary matters that have been raised during the week. There's really preliminary matters kind of in different areas. I'm just going to use to present to you, I'm going to use the objectors in the order in which they filed. And then there's also one other issue that I'd like you to consider, but we'll go in order. So the first preliminary issue was raised by Objector Lynch, and he raised concerns that there were, and I'm quoting, extra petitions that were not part of the recall certification letter.
Front of Marshfield Clerk's office.
Perhaps.
It's got a legit delay.
So that was one of the issues, and Mr. Lynch, Objector Lynch, if it would please the registrars to hear his objection about those petitions that were filed, or the petitions that were counted in the total number of certified signatures after the date of the initial certification. And if I may, Mr. Chair, just to kind of orient the discussion today. So as you're aware, there was a certificate of sufficiency issued by the clerk's office on April 21st, which was a Tuesday. The last day for filing petitions under the town's Recall Act was Friday, April 28th at 5 p.m. So Mr. Lynch's concern is that those, what he's terming extra petitions, were counted as part of the total certification. So if it pleases the board to hear from Mr. Lynch on that issue.
So that's how we're going to play this, because I have an opening statement that I wanted to make, but if you want to, then we could go through all the individual stuff. It's up to you, how you want to do it.
Point of order, please. I see Dave Riley trying to call somebody. I don't know if he's having problems or not. I don't know if you want to try and make sure that he's connected or not before you go on. He's used his phone a couple times.
I don't know.
Dave, you're on there? Can you hear us? Why don't you unmute, Dave?
Dave, can you hear us, or can you participate?
Yes, we can.
There you go. Have you been trying to, are you following where we are right now?
I can't hear anything.
Okay. So let's
Okay.
pause for a second.
Pause.
Mr. Chair, would it make sense for Mr. O'Reilly to go out and then come back in perhaps? And if that doesn't work, then one of you could call him on your cell phones and put it in front of you, and we could see if it works that way.
Thank you. I can't hear you, though.
Okay, and I'm looking at my IT people that are controlling it. The best approach would be have Dave, because he can't talk to us, or he can't hear us.
So who can he hear?
You can't hear anybody.
I thought he was supposed to.
Oh,
I think was there somebody else in there talking to him?
No. Somebody have a cell phone?
yeah, does somebody have Dave's number? I don't have it.
I do not have his number.
They're getting, somebody's getting it. Or
Does
if they're at
Dave's
home.
number
Yeah.
exist downstairs?
Yeah, it is downstairs.
Why don't we go get that?
All right.
I mean, I can use my phone.
Yeah, but we're gonna get his phone number to call.
Oh,
Lauren, would you bring your phone up?
Dave, can you hear?
I don't think so.
Nope.
Nope.
Because we are getting.
Yeah, someone needs my phone number,
You can read it up, Dave?
781-771-7716.
Hi, if you record your name and reason for calling, I'll see if this person is available.
So he can do that, and then let's say who you are, and he can pick it up.
It's just.
Sterling,
I don't know.
you pick up, Dave.
Hold on.
Take a recess.
Put it in speaker.
Unknown caller.
Hello?
Hello, Dave. Can you hear me, please?
Hi. I can hear you, yes.
Okay. We will try this and use our cell phone to communicate with you if you have anything to say.
Thank you. All right, I'll keep the cell phone and I'll still watch the Zoom. And, yeah, I can do that. Thank you, Walter. Thanks.
Thank you.
Okay, bye.
Mr. Chair, perhaps it would be appropriate to tell him that if he can't hear, he should speak up loudly so that we
Okay.
can have people.
He seems like he's coming through on the ceiling speakers too, so. All right, Dave, seeing that you've joined us now fully, we have Stephen Lynch, who's making the first presentation, and he has an opening statement that we would read. Just a second.
Mr. Sterling, Chair Sterling, I guess the question is, do you want to deal with the preliminary matters before the opening statements are made? Because there were several issues that we said we'd resolve today, and it would seem to me to kind of get these out of the way at least to get them on the record, and then go to the opening statements might make sense. But ultimately, that's
Yes.
up to you. Okay.
I agree, we should take care of it.
Okay, so I'll answer. So this is Exhibit A that I have. Everybody have a packet from me? Exhibit A is the certification letter of the recall that was sent to the selectmen on April 21st by the town clerk. Everybody have that?
Yes.
So, as you can see, on that date, there was 206 petitions that were,
Hold on one second. Just want to make sure we're looking the same thing you are.
okay.
Year.
It's fine.
Okay. I'll share with.
So on that date, the town clerk certified 206 signed petitions to create this letter to initiate the recall process. I believe that anything added to that afterwards is mute. It doesn't matter because it was added after the certification letter. Any signatures?
Mr. Chair, if you would like, you could ask the petitioner's counsel if he has anything to add, and then the board can discuss whether it wants to act on that right now or take it under advisement.
Okay.
So,
And the gentleman over
Good
there.
morning, Board Attorney Richard Ash on behalf of the petitioners. The papers that I submitted to the board, to Attorney Goldberg. Thank you. There you go. Good morning, Board of Registrars, Attorney Goldberg, Richard Ash on behalf of the petitioners. I know that this particular matter is addressed in the substance of the objections as well as it being taken up administratively right now. I would just rely on the papers and the citations that were submitted to you all. The date of certification, that the certification of sufficiency of 4/21 was prior to the last day that this petition was supposed to be certified of 4/25. We would just rely on those deadlines and maintain that within those 4 days, the clerk's office was completely within the permissible laws to certify additional signatures, and that those 4 days and the fact that signatures were certified after the date of sufficiency is not necessarily any grounds to maintain this objection. Thank you.
Issue a new certification letter, adding them to it?
Mr. Chair.
Yeah. You should go through the chair.
Okay, sorry. So was there another certification letter adding those signatures given to the Board of Selectmen?
I'd have to default to legal counsel, all the legalese on that. The way I understand the application is that once we meet a certain percentage on the precincts, that an initial certification has to be done. I don't know if the bylaws require any additional certification lettering to be issued, but from my understanding is that it's done in a proper manner, but I would still default to the legal counsel.
Mr. Chair and members of the board, this is an issue you could choose to take under advisement and address later. The last day to file the petitions was 21 days after the date of the issuance of the petitions, as you know. Assuming the petitions were issued on the 3rd, then the petitioners had until April 24th at 5 p.m. to file. And the question of whether that initial certificate of sufficiency should have been issued or could have been issued may be a different one from whether petitions that were filed by the deadline were valid. So in my opinion, that's kind of the whole legal issue. Should they have been counted towards the total number of certified signatures where the petitions came in after the original certification? Or does the fact that they came in after the original certification mean they cannot be counted? Again, the last day to submit the signatures was April 24th at 5 p.m. So again, the board, if you have questions, we can certainly discuss, or you can make a motion, or you can decide to take it under advisement and move to the next issue.
Okay, I'd like to speak to that.
Mr. Chair, just for your information, the open meeting law still applies at this meeting, and that means that the only people who have the ability to speak are those that are specifically recognized by you. As you know, the intention this morning from the board was to have, deal with preliminary matters and then move to opening statements and arguments. So whether you choose to hear from the objectors again, any of them, is up to you on this issue.
Okay, definitely.
I just have a quick statement, that's all.
Pardon,
It's just quick. So,
Okay.
as far as I'm concerned, once they closed it with this letter, that's it. Nothing should be added afterwards. There was no reason for them not to wait to the 24th till all the signatures were certified to write this letter. They had no reason to have to write it on the 21st other than political reasons, so they could have a timeline to set up an override ballot. That's why they did this.
Okay.
At 8:11 a.m.
Okay.
in the morning. So once they wrote this letter, that's it. It closed the certification process, and as far as I'm concerned.
I'll take that under advisement,
Okay.
because it is related to the signatures
Yes.
and the number of signatures and everything.
Okay,
like
I just
that.
wanted to make my point clear.
Yeah,
Thank you.
I appreciate that. So we'll take that one under advisement
Okay.
at this time.
Yep, thank you.
Mr. Chair, the second issue that was raised as a preliminary matter was the request to sever, Mr. Lynch's request to sever his objections from the other objections that were filed timely. And to the extent, we don't know yet whether the objectors have even identified a lead petitioner, as was requested. I guess that question could be asked before we even move to whether there's a need to sever. So I know the objectors are here, and if you wanted to ask that question to me, that would be an appropriate time to be informed as to whether a lead objector has been identified.
And following legal counsel, has there been a lead?
So I didn't file my objection in conjunction with any other objector.
Okay.
I filed it on my own. Okay, some of the issues overlap, most definitely, but the arguments might not be the same. And I have my own particular arguments. Like I had sent to Lauren, I sent her an email saying that I'd be willing to let the other objectors go first if you would liked, and if they covered everything that I wanted to cover, then fine, to expedite things, I wouldn't speak. But I do want to do my presentation, at least, if I could do that.
Mr. Chair, the other objectors are here. Do you want to inquire as to whether they identified a single individual? And if not, we can talk about what to do next.
Okay. Following legal counsel's suggestion, are the other objectors here, do they have an issue, or are they set up a lead attorney, or basically being individually presented?
Do you have a comment?
Yeah, I have a comment. I'll make a quick comment. Joseph Pasevich Wilson wrote, objector. From the guidance letter that I saw, there was no requirement that we have a lead person. I think it was from the past meeting and from this guidance letter dated May 11th, the idea is that it was Registrars requested a lead objector be designated to make more efficient use of time. But
I understand.
I think Mr. Lynch's point is that he doesn't want to be constrained in any way by arguments from other people. I've already filed papers that I accede and I assent to Mr. Lynch and Ms. Keith's statements.
Right.
So I think the only thing was that it's just to protect the ability so he's not shut out.
That's
or
true, and that was
precluded.
not the intent at that time. We were just trying to set up procedural, not really knowing how many or how long something might go, so we would be able to try to have a clean discussion and everything like that. So hearing from nobody else, I believe that there is not a lead person. So these will all be individuals
And-
that
and-
making their presentation, and we'll take it
I'm going to be a little
individually.
quick, too.
Yeah.
I think it's to avoid repetition.
Right.
Thank you.
Mr. Chair, given that there is not a lead petitioner that's been, a lead objector that's been identified, my suggestion, in fairness order, would just be to go in order of the filings, which was Mr. Lynch, Mr. Pasevich, Mr. Kelly, and, Ms. Keith, and Mr. Kelly. So Lynch, Pasevich, Keith, Kelly.
Yes.
Okay? All right. The next kind of preliminary matters that were identified were public records requests. First, for records from the fall of 2025 relative to a different recall petition, and then some additional records requests for records from April 1 to May 1 regarding the petition. I think the question for you all to think about here, and again, I don't know that there's any testimony or comments needed unless the board thinks that. My understanding is that some of these may have been provided and some may not. So, again, this proceeding, in terms of what the statute says, doesn't say anything about records requests. They would typically be handled under the public records law, and any objections or appeals about not receiving records would go to the supervisor of public records. So, in my opinion, you could take note of these comments, essentially take it under advisement, and move to the next objection, or move to the next matter.
Because the public records request is basically outside of my jurisdiction and my authority. I have to leave that to the town legal counsel and things like that. We'll take it under advisement if it needs to be brought up later at a different time, so.
Okay. The next matter, Mr. Chair, is the comments about the petitioners, the lead petitioner and the other identified petitioner not appearing today. And so, I think their counsel is here, and so he could speak to it, but I just did want to point out that no summons for their appearance today was issued. I know there was some concern that they were flouting the jurisdiction of this board. Under state law, they have no obligation to defend their petition. I know that there had been comments in the witness list that there were questions that the objectors wanted to direct towards them. And it may be that it just wasn't specific, that the petitioner, that the objectors were requesting that subpoenas issue to them. We didn't get any specific subpoena requests from my review of the materials. If, and we can talk about this with respect to the signatures as well. When a subpoena is requested, it needs to be clear that the request is for the issuance of a subpoena. The town clerk would prepare a blank, which she would sign and make available to the objectors. They would come and pick those up from the clerk. They are responsible for serving those subpoenas. That means anybody who's over the age of 18 who's not involved in this matter at all can bring the subpoena to the individual. And the objectors would be responsible for paying witness fees. And that's $6 per day and 10 cents a mile to require people to be here who don't want to be here. For people who are willing to come, no subpoenas need to be issued. So to bring that all the way around, no subpoenas were issued to them. So Mr. Attorney Ash is here, and perhaps it would be helpful to hear from him.
Sure. Mr. Ash.
Yes, thank you, Attorney Goldberg. I agree, there were no subpoenas issued on this matter. I maintain that the issues in front of the board this morning are legal in nature, not factual, and that you should not need any testimony from my clients, the petitioners. However, in light of their scheduling and their schedules today, they were not available, but at the last minute, they did move some items around, and I have arranged for them to be here at 11. I believe they have about an hour. If the board has relevant testimony related to the legal issues that are in front of you this morning. And I want to make that very clear. If the board would like to ask relevant legal questions to the petitioners, Ms. Brate and Mr. Costello, they can be here at 11, and they have about an hour. And I hope that the board can let me know, of course, so that I can contact them and confirm whether that is necessary or not. Thank you.
I would like to ask them some questions under oath.
I was going to ask, because he only stated the board only, and did not state
Right.
anybody.
No, I have questions for the petitioners.
Maybe to facilitate it a little bit, if it would be possible, maybe a really quick synopsis of your questions so that we could see it first to make a determination as to, does it have to be held over for another time or something of that nature? instead of having multiple people, if you could just give me,
Well, I don't know if we're going to even make it to the May 27th hearing, depending on your decision today, so then I won't get to question them under oath if we don't get to that date. And I have questions about how the process was done, the people they handed these petitions out to collect the signatures. That's all part of the law, how it was supposed to be done. Did they tell them, you're not allowed to let a spouse sign for another spouse? And did you direct people? Did you know that people were signing for other people? I have questions to the law to ask them.
okay.
I understand why they might not want to testify under oath, because either you have to admit that you told people to sign,
Right.
or you have to,
I'm looking,
or you have to perjure yourself.
I'm going to
Or you
object to
take the
even,
Fifth Amendment.
I'm going to even object to that line of questioning. If there are relevant legal issues that the petitioners are it is necessary for them to be here to discuss.
right. I'm just trying to facilitate the movement of this right
Yeah.
here.
I only have a couple quick questions for them.
That's true, but as we get closer to the time that they are available, if we can sort of bring it together, because there's only a few objectors right here, and they can discuss the questions and make sure we're not overlapping, asking the same question.
Believe me, I'm not holding anything up. I am going to be quick, leave time for my brothers to do their case, believe me.
At the time it arrives that the petitioners are available for us, we will then look at that again and discuss it.
Okay.
Yes.
Okay, Mr. Chair, so you're going to take that under advisement?
Yes.
But is it fair, Mr. Chair, to say that Attorney Ash's client should be aware that their presence may be requested for the 11 o'clock?
Correct.
Okay, all right, thank you.
Thank you.
The final matter, well, actually, there's two more matters. One matter is, there were several objections or amendments, and I'm putting it in quotes because they were referred to as amendments, and there was one that was referred to as an objection, that were filed with the town clerk's office after April 28th at 5 p.m. And the law, when it comes to voters, is that they're required to follow deadlines. They're required to comply with deadlines. So where, I'm sorry, the 48 hours, it wasn't April 28th. I forget what date it was. The 2nd, the 3rd,
26th.
the 6th? No, can you just look? We need the, I'm sorry, I apologize. April 28th was the Friday, right? Just give me 1 second. I apologize.
The 24th was the deadline to do it, so 2 days after that.
It was the 26th. So it was the 26th. So these objections that I'm referring to,
That's right.
oh,
So you guessed the 28th.
the 28th.
That's right.
Yeah, it was the 28th.
Two working days.
Yes. So sorry, I was right when I started.
That's right.
So these were objections and purported amendments received after April 28th at 5 p.m., which was the deadline for filing any objections. Under state law, the deadline for filing objections is 48 weekday hours after the last date and hour for filing the documents in question, which were the recount petitions. So they were due on April 24th at 5 p.m. The 2 working days, 48 weekday hours, brings us to April 28th at 5 p.m. As such, Mr. Chair and members of the board, I would suggest that you take a vote to reject any late-filed objections or amendments, regardless of content. If you want to hear from the...
Can I just ask you one question about that? Lauren, can I ask you a question?
Mr. Chair, everything should go through you. If you want me to answer questions, I'm happy to.
Definitely. So I'm just trying to get a handle
Yeah.
on this whole thing. So it's more additional information being submitted?
So I filed the objection in a timely fashion, but then I made some amendments to my objection. So that's a little bit different than filing an objection after the date. I just amended my actual objection.
Keith also wants to be here.
And Ms. Keith?
Is this on? Pam Keith. I don't have the text. I should have the text of the law in front of me. I didn't realize you were going to address it. But 55B7, the clause reads, there's an or clause after that. It reads that the objections must be filed 2 working days after the last date of the petition being filed, or 2 working days after the last date that the petition must be certified. which if you take a date, I mean, if we go with the very latest date, the petition was filed on the 24th, the date that must be certified, according to our charter, was 14 days later, which would bring you to the 6th, I believe it was Friday, May 8th. 2 working days after that, you ignore the weekend, is all the way out till May 12th. And it states, the law states you have 14 days, you have 2 working days after the date it must be certified, whichever date is later. The law seems to read that people who are making objections have the later date and have the latest date. The date that, if we go by the very latest date that the petition was filed on, which would be Friday, April 24th, objections could have been filed all the way to May 12th, according to that I read. Obviously, I'm not a lawyer, but ignoring the "or" clause, I don't know that you can ignore the "or"
I
clause.
have to default to legal counsel on this because you're into some legalese, and I did a little research, Chapter 55, I don't know if it's even applicable to what we're doing here and what the regulations are, and that's where I have to default to legal counsel.
55B
as to-
is what's applicable to
Yeah,
objections here.
but again, this is a recall that's under the town's charter and the bylaws. I looked at the state, I asked the state a question about recalls, and they have nothing on recalls at all. They are silent, they default to local.
I would-
That's why I have to default to legal counsel as to what is the legitimate and applicable application.
Well, if I could just tell you, there's one case in particular that I read early on, which is the Mora case, Mora versus Strange, I think it is. And Mr. Mora actually won his case. The person who signed the petition pages did so wrongly. He won his case. The court ruled that 55B7 is the timeline and the timeframe that applies to
Yeah,
that
Again,
case.
I'd have to default to legal counsel on this one.
Mr. Chair, I think even if the board chooses not to act on these, or chooses not to act on these later filed amendments or objections, in my reading of both Mr. Lynch's and Ms. Keith's objections, those, they, except with respect to a number of signature pages, the content of their objections was covered in their original filings. Again, the board could take this under advisement. We've taken a number of things under advisement, and I can look further into that question, and we can also identify which are the specific issues that were raised later that weren't raised earlier so that the board can take a look at that.
It sounds, because Laura has reviewed it, it sounds like it's not a substantial modification. It might be a tweaking and clarification more than anything else as to these submitted. So we'll take it under advisement and keep them open at that time.
So, Mr. Chairman, for instance, like on one of my amendments, I changed the word from without to with,
Right.
That's-
That's a clarification.
Yep.
It's not substantial.
Yeah, Mr. Chair, I would consider that to be a typo.
Okay.
Okay, so the last thing on the preliminary list is scheduling. And as you and I discussed earlier, the date of the 27th is problematic based on prior commitments. In addition, my understanding from the petitioner's counsel is that that date, he has a limited timeframe. From review of the objections, even without the later objections filed by Ms. Keith, there are a significant number of signature challenges to review. We had discussed moving the review to a separate date. And so, in my opinion, it's unlikely to be concluded in 3 hours. And therefore, my suggestion for the board's consideration is perhaps to move to the next date, which is the 28th, to do the full day of objections. In addition, I just wanted to point out that where no specific subpoena requests were given, if people were to ask for them, I think we said end of day Monday, which is a holiday, so we wouldn't be able to get those turned around to the to the objectors until, let's just say, even if we did everything we could, early on the next day, Tuesday, the 27th, the 26th, and that would just leave one day for people to be given notice. So I do think it's appropriate if the board is amenable to move the date forward a day. That way, the petitioners and the objectors, if they have people they want to subpoena, can notify the clerk's office, and we can get those prepared as early as possible on Tuesday, and at least it gives people a day and a half to figure out their schedules once they've been served.
Okay. Please. Because we're just looking at possibly setting up a
Right.
alternate date.
Right, again, Joe Pasevich. First of all, as far as preliminary matters go, I did request information in a letter addressed for the record, and I did send it to Ms. Goldberg, and I wanted clarification on some issues. That was, and I haven't received any answers at all. For example, it's never been explained to us exactly who hired Ms. Goldberg and what her role is here.
That's all out of order right now, Joe, because we're just looking at trying to establish a date that we're going to be reviewing the signatures because
Okay.
we have a conflict with a couple of people, so.
But my understanding was that there was some documents to be handed out in responses for information, and we haven't gotten to that. And are we going to get to that at some point?
Hang on for a second. Do we have any other additional?
Mr. Chair, as you know, there were several things that were sent, and we said we'd address it on Friday. I certainly have not prepared any information for distribution, and I wouldn't have any of that information. It would have to come from the town. I think, you know, Mr. Objector Persevich I understand that he's requesting some records under the public records law, as we mentioned earlier. Certainly today, after the hearing, we can follow up with the town clerk to see what records might be available and whether we can get them to the petitioners for next week. But that's, I think, the best that we can do with that request right now.
I object to that characterization because this is pertinent to the conduct of the hearing. It is not under regular public records request, which is a 10-day request. Minimum. So this can't be held under constrained to following those rules because it's pertinent to conducting a fair hearing. Just as if we're to ask for someone to appear here, how do we know that they refused to be here? There was no avenue or description of a process for us to follow. If we requested someone to be here, how would we know they didn't want to be here when we have to go through that? Thank you very much.
Yeah.
Mr. Chair, in the follow-up email, Ms. Keith had asked, sent an email to all of the parties involved, including the registrars, indicating that she would request extra time to prepare the documents that were requested to be prepared for today, which included the legal arguments and relative to why the petition wasn't valid or legal. And based on the timing of trying to get this organized and get a letter out to the group, it took longer than was anticipated. And so, in response to the concerns raised by Ms. Keith, and with your permission, I sent out a further scheduling memoranda, and that indicated that there was additional time, essentially for all the parties, and we pushed the signature challenges off and the date for filing those signature challenges off. So that's essentially the reason for the date schedule. With respect to, I think what Mr. Pasevich is referencing is petitions, or copies of petitions from a fall 2025 petition, recall effort. To the extent that Mr. Pasevich has legal arguments to make based on those petitions, or what he thinks is in those petitions, he certainly can make what's kind of known as an offer of proof. He can tell us what he thinks he's going to find in those and how he thinks that's going to be relevant. And the board can follow up and request the clerk to provide those. The board can ask the clerk whether those are available as part, of the follow-up from today, and where we're requesting an additional day to prepare information and send, allow time for subpoenas. That would give us a little extra time to follow up on that.
Okay.
And if I may, Attorney Goldberg.
1 second. I do have a commitment on the 28th, so if we pushed it off to the following week,
Yep.
would that allow more time to provide them information they're requesting, but I would like to see what you're looking for from those documents. What do you expect to see there?
Well, my request was not just limited to the petitions from last year. My request was a description of what the hiring arrangement is with Ms. Goldberg, because she seems to be acting like a judge and your advocate, your counsel. I've referred reference to our legal counsel now from the chair at least 3 times. And I just don't know what the relationship is. I think that should be made clear. And I made several questions, and I asked for that information in that email, and I haven't received anything yet. And now I'm being told I have to wait for 10 days because this is a public records matter. It's not. Again, it goes to the fairness of the proceeding and an understanding of the process. Thank you.
It's interesting.
If I may, Board, Richard Ash, attorney for petitioners. With respect to the 27th, I have a commitment in the afternoon that I cannot move. I'm less, just for transparency and for the board's knowledge, I am less, I just want to be here for the closing of the legal arguments and for the decision on the legal arguments. If the board believes that that is going to be wrapped up on Wednesday, the 27th in the morning, and we're bifurcating the claims, then that's fine. But if that's going to go potentially into the afternoon, or if the board would like more time for other reasons, certainly it's my client's anticipation that this is concluded sooner than later. So I would hate to see it moved out for a week or 2 just based off of a small scheduling conflict. But I do want to make sure that I'm available for the legal issues to be adjudicated. And it sounds like that may happen on Wednesday morning. So it very well may be a moot point. In light of the other issues, I don't know how that changes the scheduling, but I just wanted to put that on the record.
Thank you. But at this time, we don't have a crystal ball to tell you exactly how things are going to run. We're going to leave it as open as possible so everybody can be heard, and it's a fair, open meeting activity. We don't want to shortchange anybody's activities on that, so.
Can I speak, please?
Sure.
Sorry. I just want to correct Ms. Goldberg. She said that I requested a time continuance based on like needing more time to do the legal arguments. What happened was the packet was supposed to be numbered for the signatures, and the signatures were the earliest thing to be put in. We were supposed to put in signature line items back on last Thursday. So I asked for a continuance because we didn't have a packet on Wednesday morning. We still didn't have a numbered packet. I asked and the law that she's using actually is a state law that allows you to pass in signatures 3 days before the hearing. So I was basically asking to move it to Monday or Tuesday. She moved like everything to Tuesday and moved things. But I then followed up with a question. She then wrote an email that is different from this letter that we got, which Mr. Pasevich referenced earlier, was given to us several different ways. Certified mail, came by hand by sheriff, was emailed to us. I think I even got a town clerk's copy. I think I got it 4 times. And it stated that you'd be talking today about legal matters and also maybe moving on to a little bit of the signatures. It left things kind of open for whatever talk. The email that I got after mine was a simple request to move the signature into this week. The email that we got instead was in bold print that you would have a meeting today with no vote anticipated on anything, and a meeting in bold print on the 27th, already a set date. And I then emailed back a long email that asked you, under the law, under this timeline of 55B7, you are supposed to make a decision in 14 days after the last date that people can complain, which if the last date people could complain is May 12th, then 14 days later is May 26th. So if we move the meeting to May 27th, you basically are making the statement that you're not making a decision in the timeline. The rest of that timeline states that the town clerk can cause ballots to be printed. What that means for Eric Kelly, I don't know, but I wanted a clear-cut answer as to whether you recognize the law and that you are supposed to make a decision within 14 days after the last date. and whether you're stating that you're not going to make that decision because you're moving everything to the 27th or the 28th.
My understanding is that we're trying to be as flexible as possible to, address everybody's concern, but I'll have to default to Lauren because she was the one that responded back to you, and she did talk to,
She only responded by saying, we talk about it today on the 22nd.
Mr. Chair. Thank you. So a couple things. Getting the numbered petitions to the objectors was a priority, and for various reasons, those petitions were not provided until late in the day on Wednesday, which is why on Thursday morning, we spoke, and then I sent out a revised schedule. That revised schedule I did run by you. It was a scheduling matter, and the decision was, let's make sure that we give everybody a fair amount of time with the petitions. What we did do in particular was push the date for filing the signature line-by-line challenges until yesterday at 5 p.m. And it's right there in the letter, and it makes clear that there was additional time for that, again, with the goal of not disadvantaging the objectors because they didn't have as much access to the petitions as would have been appropriate. With regard to the comments about subpoenas and what that looks like and how people would know, that was also addressed in detail in that email, which again was the morning, 11:43 a.m. on Thursday, the 14th. There's a whole section on it and explains what the responsibilities are in order to do that. Finally, with regard to the dates for action by the board, that statute is meant to address a number of different scenarios, including, and most importantly, nomination papers. When nomination papers are objected to, there's a very short time between the date that those objections are made and the date that they need to be acted on in order to be able to print the ballots and hold the election timely. We are under no pressure like that in this situation. In order to move forward with the process, there would need to be a determination that the petition is valid and it has the right number of signatures. That's been challenged. There is no ability, in my opinion, for the town to move forward at this point to print ballots or hold a special election. So there's zero risk of that happening. Again, and I think you said this, Mr. Chair, the concern is to make sure that everybody, especially the objectors, has a fair opportunity to make their case in a way that they feel comfortable with, that they have the information they need. With regard to, finally, with regard to the public records request, I believe that what I just said, and I could certainly go back and listen to the recording, is that what would make sense after this meeting is to follow up with the clerk about what is and is not available and to see when we can get that information provided. Requests for records are different than a request for information. I'm sure you could defer to town council about how I was hired to represent you all, but that's not the type of thing that this board, kind of as judge and jury, is responsible for responding to. There is no requirement that you respond to those kinds of requests. So for all those reasons, in my opinion, you are not under an obligation to act on Wednesday. You certainly can push the hearing on the signature challenges. Again, I think, especially given Mr. Pasevich's request for information, it sounds like that would be beneficial. I'm not certain why that would be a problem, particularly where the town cannot print special election recall ballots, but as a matter of law.
So going back to the question on the table is that looks like we have a conflict on the 27th, and we are looking at another date that would be appropriate for us to have the signature or even as continuation of this discussion on that date. And again, with what Lauren has just mentioned, the relationship of days and everything of that nature, I don't believe it's really applicable to what we're doing right here as a recall discussion. So we're looking possibly with, Dave has a conflict too on the 28th. So we're looking at the possible 29th maybe? Oh, no, that'd be a Saturday, right?
My conflict is on the 28th, which is Thursday.
Thursday.
29th would be a Friday.
29th is a Friday.
So most important, of course, is that the board is available and has a quorum. So, if I don't know if Mr. O'Reilly wants to also weigh in on what his schedule is, and if not, we certainly could coordinate that immediately after this meeting and provide a date that is where all of you are available and schedules align.
Okay.
I can do, this is Dave, I can do May 29.
All right, and Dave, you can do the 29th.
Correct.
So I'd make a motion that the
Hearing be
the
continued.
hearing be continued until the 29th of May.
Here.
In this chamber, starting at 9 o'clock would be appropriate. Again, I don't know, if Attorney Ash, yes? So,
Yes, thank you for the consideration.
yes.
Therefore, Mr. Chair, because Mr. O'Reilly is participating remotely, you'll need to take a roll call vote. So we had a motion. Is there a second?
second.
Okay. So now you could ask,
All
each
those-
individually.
All those in favor?
Aye.
Aye.
Yes, say your name.
Dave Kolar, aye.
Can
David O'Reilly, aye.
Walter Sterling, aye.
can I just make a comment on that, please?
Sure.
So you asked the petitioners if the timeline was all right for them.
I apologize. I should have, but I thought I saw nodding in the.
I'm just, I'm a process person, okay? So that's,
Yes. I should have opened it for further discussion.
and I just want to speak to the question about why the board hired Lauren to represent you. No one's accusing the Board of Registers of any wrongdoing here. So I really don't understand why we,
It was never the intent. I believe it is just that all three of the two Daves and Walter are lay people.
right.
You're not.
We understand that you just did what your statutory duty was to
And for-
to certify the signatures that were put in front of you.
That's right.
Right.
yeah.
So
And-
we're not accusing you of anything.
Attorney
So
Galvin.
I don't know why you need a lawyer, but anyway.
A little bit, but I think it's probably out of order exactly the relationship of why certain people are hired and everything like that.
Right, okay, all right, no problem.
That could be done at a later date.
Yeah, so, one more question. So now that you're extending the date, are you extending the timeline for, request for, subpoenas?
I would feel it would be appropriate because the first time the subpoenas would have been coming out for the 27th if
Right.
you have people that need it. And you have to do it a formal, I understand that if you don't ask it in a formal format, that they cannot send out the subpoenas and follow up on that.
Right.
It will be necessary for you to,
I did
I believe it would be-
submit a subpoena list to you, though.
but, go ahead.
I was going to say, Mr. Chair, it wasn't clear from the way, it just said witness and subpoena list. It wasn't clear that there was a request for subpoenas to issue. Nevertheless, if we're moving to Friday and people could get the subpoena lists to specifically requesting that subpoenas issue, and I can look to or you could look to the town clerk to say if they could get it, let's say by 2 o'clock on Tuesday, then they could pick up those subpoenas by 5 o'clock or, 4:45 before the clerk's office
good, thank you.
closes.
Yes.
Does that seem appropriate?
It seems appropriate.
Right, thank
Do you
you.
think you need a vote on that, or do you feel comfortable just establishing that
I
deadline?
was going to amend the motion that any.
I'm okay with that for what it's worth.
Okay, yeah.
Okay, thank you.
I would make that amendment to the motion that if a subpoena is necessary for a witness, that it be formally requested through the town clerk by 2 o'clock on
Yeah,
Tuesday.
'cause I listed my people on the witness and subpoena list, so I should have separated it right then. Witness list, subpoena list.
Mr. Clerk, Mr. Chair, without being overly formal, it wasn't clear from reading that it was actually those subpoenas were being requested. Certainly, it is not overly burdensome to do so, and we can certainly take care of that. And if there's any further people, we can certainly treat that witness and subpoena list that was given as a formal request for the issuance of subpoenas. And if there's anyone else to add to that, it should be by 2 o'clock
Right.
on Tuesday.
Thank you.
I just have a quick question, because I'll probably be helping the town clerk prepare those summonses. The deadline for them to submit the subpoena list to us is 2 PM on Tuesday,
Correct.
and then we'll have, if there's
2 hours.
1,000 here, we're not gonna be able to get that done in an hour.
Mr. Chair.
We can always look at that at which time, if it becomes overwhelming. Again, from my understanding, the subpoena is for those that are basically refusing to come. Those that are willing to come do not need a subpoena, correct?
As long as we have name, address, we'll prepare the summonses.
How do we know that, though? How do I know that people I put on my witness list, like Sean Costello and Laura Brait, last night, I got an email, or the day before, saying they weren't going to show up. So how do I know that unless I subpoena them?
Just ask them for a summons, and there'll be summons.
Well, with respect to the petitioners, they're showing up today to answer questions. For the purposes of continuing this hearing to next week, I'm not going to advise them that they need to show up again. Today, they're answering questions that will be relative to the hearing in general, and if this hearing is continued to another week, they're showing up voluntarily today. The subpoena that would issue next week, their appearance today, if that is a potential, is in lieu of that.
Mr. Chair.
I'd have to default to my legal counsel on that.
Mr. Chair, I think the question will be for the board, what does it determine is relevant testimony? The testimony that one would expect with respect to signature challenges is really just from the objectors to say, we think these two signatures look similar, we think, these were signed by the same person, that kind of thing. So I'm not clear on what the additional testimony might be, and it may be appropriate for you to kind of provide some guidance to the objectors that if they believe that there's going to be a different type of evidence or testimony that's needed, that they give you, again, kind of that offer of proof, what that testimony would be about. And then if the commission determines that if the board determines that issuance of those subpoenas is consistent with that expected testimony, then Mr. Ash would have to decide whether his clients will comply with the subpoena or not. That's a different question than what we're dealing with today.
Mr. Chairman, I can answer that for you, for her question about that. So here is the signed certified petitions. We've gone through all of them. There are some pages in here that one person signed every single signature on the page. That is a crime. So I'm going to want to subpoena people who wrote those pages.
Okay. I mean, again, we're looking at the number of subpoenas that possibly.
We're not talking about a woman who walks into Shaw's and signs her husband's name too, and it gets by the collector. I've collected signatures my whole life. We're talking about an effort, a conspiracy to sign other people on these pages.
You understand that, and
I'll object to that.
we'll get to that discussion under signatures, but again, we're looking at subpoenas right now and issuing that, and we're afraid of how many, but I guess, as legal counsel says, if you could give us a synopsis or the reasoning for the subpoena, and I don't know, I've never been issued one or received one, I don't know if it states the reason why you're being summoned or something of that nature, at least we have an understanding so that we could review it as a board.
Right, because I'm going to want to ask usually the first person who signs a page, who we think signed the whole page, did you sign this whole page for these people?
That'll be discussion under signature debate.
And
Right.
Mr. Chair, I would suggest if that is the approach that's being taken, it would be better for the objectors to notify those people as soon as possible, even without a formal summons, and ask if they're willing to appear. I know that there's a street list that's required by law that has names and addresses. Certainly, the the objectors could contact the people by leaving something at their place of residence. Again, the use of the subpoena is, typically intended to go to the actual heart of the matter. Did the person sign? In my experience, it is somewhat uncomfortable to have a million people be subpoenaed. And I'll just tell you, for the purposes of this, to give context to that, I used to represent the Secretary of State's Elections Division, and part of that responsibility was representing the State Ballot Law Commission, and they heard challenges like this to initiative petitions and nomination papers, et cetera. It is a significant effort to subpoena a lot of people. It's a significant effort to actually get everybody served, that's one thing. But also for the commission at the state level, and it would be for the board, to manage all of those people. And so, I think, again, it would be highly, highly appreciated from the board's perspective to get that list as soon as possible so that we can consider whether we need to, schedule 2 days for people to appear, or whether we want to try and give people kind of an expectation of a wave. You know, the first wave will start at 9, the second wave will start at 11, so that people aren't sitting here all day. So again, I think, you know, the other thing I just want to point out is that the board has the ability under state law to look at the signatures and make a reasonable determination of whether they believe someone signed for, you know, more than once. And typically, in my experience, what that looks like is essentially the objector saying, I'd like you to look at lines X, X, and X. If you can see that the Y is the same, the T is the same, you know, the way they kind of flourish at the bottom is the same. It's usually a 2-3 second explanation, and then the board uses its judgment. It can deliberate, discusses. If the board believes that signatures were signed, that a person signed more than one signature, then only one is counted, and the rest of them are, you know, discounted. So I'm not certain, really, that the board needs testimony from, you know, dozens and dozens of people to answer that question. With respect to whether anything that occurred was a crime, the place to adjudicate that is not here, Mr. Chair. It is perfectly acceptable for people to have whatever, you know, draw any conclusions that they want, but it's the district attorney's office that prosecutes crimes, not this entity. So I do think if that's the point of subpoenaing a ton of people, it'd be much better directed towards the district attorney rather than to the Board of Registrars.
We've definitely gotten off track a little bit, but that's how we're going to be approaching the signature.
I understand, but you got to understand our position too. I've only got to go through half of these. The timeline provided for us since we got these, the numbered copies, you don't know how hard it is to go through 4,000 signatures and figure out how many of them are forgeries. But it's pretty obvious when you go down a page and then they're carbon copies.
Again, we can't debate.
But anyway, we're doing that another day anyway, so we don't say,
Right.
I'm ready to.
You have your work cut out for you to contact your witnesses to verify that they could be here at least starting on the 29th and possibly extending
Right.
it if we have a lot. But again, working through the town clerk's office,
Okay.
we can determine that. Again, because this is an informal meeting,
Yep.
we possibly, if we find that you're going to bring in, 300 people or something of that nature, then we might move it out a little bit more.
Well, there's 4,000 signatures for us to go over.
It is, and as registrars and Dave, remotely too, we've done this for a couple of years.
And I
A lot, but we have
totally
a lot of
understand what you had to go through.
experts. But that will be a whole.
But now you got my mind off track off my presentation and on what she's doing.
That's why I was trying to keep it to the date. What are we doing? We're looking at a date, the
I was
20th.
all ready to do my presentation, and we got off track here for an hour, so.
Like to take a 5-minute recess and then come back?
No, I'm ready to go.
But again, we're back on the 29th at 9 o'clock. We will be continuing this hearing for wherever we get through today's portion.
Right.
Continue there, and we'll discuss that. But
Mr. Chair, if I may, so the dates that we provided, we extended the date to provide objections to the numbered petitions that were provided by the clerk's office on Wednesday afternoon at 4 p.m. That date was extended till last night at 5 p.m. The way that the process is outlined before the State Ballot Law Commission, which is essentially what we're modeling this after, it's not exact because it's not the same exact circumstances, is that as I indicated, the petition line numbers would be required to be provided, as Ms. Keith indicated, 3 days before the date of the hearing. But usually, that leaves only 2 or 3 days from the date that the objections are received. So, in my opinion, and it's up to the board, it is not unreasonable to give them more than a week to go through those numbers. And we'll get to that when we get later. But if today the board has taken under advisement whether the, let's just say the later filed objections, amendments are valid, I would point out that Ms. Keith has objected to pages and pages and pages and pages and pages of signatures. Those were line by line. those would be valid to be raised, or at least I would suggest to the board that that be how that's handled. The remaining petitioners identified all of the signature lines. And what we said was being requested, and again, this is to provide some order and ability to address this, is signature challenges by line. So in my experience, that does not mean all. It means particular lines with particular reasons. And if you look at Ms. Keith's objections, she color-coded and she said, these I think were signed by the same person, these I think were questionable. And Mr. Lynch, Mr. Pasevich, I'm sorry, I can't remember which, did provide kind of a tabulation, a list of signatures or pages that he had concerns over. So I think there is a large number of petition signatures that could be challenged, but in my opinion, and this will be something for the board to rule on, and it doesn't have to be now, there's a question about whether saying all signatures is sufficient for this purpose, or whether that does lead to the circumstance where we have 4,000 subpoenas out there and, a circus-like atmosphere. So I know we want to at least get through the legal arguments, and I think we could wait until after we've heard the legal arguments and then kind of come back and address some of these kind of floating questions that you took under advisement, so that everybody's on the same page before we adjourn today.
Okay, definitely. I do feel that the objectors understand our limitations and what we're really here to do. And using the term all could be very generic. Again, the burden of proof is.
That was me that did that.
Right.
Let me just.
That could be a clerical error.
Can I just explain it to the board? So Ms. Keith's objections, line by line, she specifically is aiming at the precincts that were really close to 15%, to bring them under the 15% by those forgeries. My intent is to show absolute intended fraud by the petitioners. Or the 20 people that they allocated to, maybe not just them, I don't know how many signatures they collected, but the 20 people that they gave these to collect signatures. This was an intended fraud. When you see the pattern through this entire thing, you will see that someone had to do this on purpose. This was not a mistake that they had fake signatures.
Objection.
I'm going to have to take all the signature stuff under advisement, and I understand that you have a separate approach compared to being the individuals. That I will have to discuss offline.
I'm trying to protect the political system that we have here in Marshfield by doing this. That's my goal.
I understand your position, and it's being recognized, and it's taken under advisement, and as we get closer to reviewing those signatures, we'll determine the appropriate approach, because you're getting into a legal application and law enforcement and a bunch of other activities that.
Because like in Precinct 7, Pam didn't pick out forgeries, because she was just trying to get the ones below the 15% criteria. I picked out the forgeries in the entire packet.
Is there a legal argument on the floor?
No, there is not.
Okay, I'm going to object to everything that tirade. Thank you.
That's noted. But again, this is an informal meeting. We're having discussions, and
I'm just trying to explain my viewpoint so you understand where I'm coming from.
And at that time, I'll have legal counsel, and we'll determine what's appropriate, what's within the preview of the board to do. Our hands are tied by certain provisions too, and I understand.
We will be putting together a total package after all this and giving it to Elections Division anyway, subsequent to all this.
Still, we're not looking at hundreds of people being subpoenaed and called in for the 29th.
No, absolutely not.
Thank you.
All right.
Okay.
Mr. Chair, so that takes us to the end of the preliminary matters. Does the board want to take a 5-minute recess before you hear legal arguments? Because now would probably be a good natural break if there is an interest in that.
Sure. I heard a yes on the phone.
So, Mr. Chair, do you want to do a 5-minute recess or a 10-minute recess?
We'll do a 10-minute recess.
And so we'll come back here in 10 minutes, which would be 10:25.
10:25, yep.
Thank you.
Thank you. Okay, we're going to reconvene the meeting at 10:28.
Mr. Chair, if I may.
And you may, please.
During the break, there was a discussion with the objectors about the process that will follow on next week on the 29th and what will and will be heard or will not be heard by the board at that time. From my individual discussion with the objectors, certain objectors made line-by-line challenges. One of the objectors made a list of challenges with lines, but didn't indicate that, in general indicated that there could be some forged signatures, but didn't put that code next to the lines identified. And as we heard from Mr. Lynch before the break, he's just objecting to all of the signatures for fraud or forgery, as does Mr. Kelly. So I think the question for the board at this point is, whether the board believes that additional clarification is required to instruct the objectors as to what the board expects in order to be able to deal with next Friday in an orderly manner. It is appropriate, in my opinion, to establish deadlines for people to comply with, for the objectors to comply with, just like it's appropriate to establish deadlines for the petitioners, and the board did that. I think from the comments, and certainly you can ask each objector and Mr. Ash what they thought or what they think is appropriate for the signature challenges. In my experience, again, with the State Ballot Law Commission, but also with many other boards of registrars over the years, when a board says we're going to do signature challenges by line with a reason, essentially what one expects is a list of the actual lines that are being challenged with the reason next to it, fraud, forgery, or whatever it might be, by line. And that's why we bait stamped, which means we numbered the petitions in a cohesive manner, 1 to whatever the number was, so that would be easy for the board. And so I think perhaps it would be appropriate, and I know we really want to move on to the argument, but to ask each of the objectors, what their understanding was, and if you give them, let's just say till Tuesday, whether they can produce that objection list for you in a way that's useful. I note that Ms. Keith's later filed objection and her earlier objection both refer, no, the earlier filed, or maybe both, refer to their own numbering of the petitions before the bait stamp number. And so, regardless of how you decide to proceed, it may be appropriate for the board to request that she just reformat so that we're referring to the bait stamped numbers. My understanding is that those are in order of submission, so that even if they weren't in the same order when she had them originally, she could put them in order based on the time of submission. So I leave it to you, Mr. Chair.
Oh, thanks. Does any of the Daves have a comment or suggestion?
The objection, Dave.
Well,
The
yeah,
board.
I could say, in order to meet any such deadline next Friday, we would need to get those signatures that you want us to review ASAP. Do you have an idea how quickly you could turn those around in order to get subpoenas if needed, give us a chance to review them?
You're asking me?
Well, I'm starting with you because I know when you...
Well, I thought she wasn't going to allow me to do that.
Mr. Chair, that's of course up to you.
I know in yours
Yeah.
you said all, and that would just sound like a blank.
So I did all because I just didn't have the time to review line by line and write it down. So yeah, if you're going to allow me to do it, then I will do line by line.
I believe it would be best that we have line by line. This way
Yeah.
here we can have all the objectors and we don't have to go back and.
It's just that some of Pam's stuff will be repetitive in that case,
We'll recognize that as like.
Mr. Chair, if I may, I'm going to object to any signatures that were not set forth line by the deadline that was already extended. I mean, you gave clear instructions. You extended deadlines already. If you haven't received a list of line-by-line signatures with specific reasons by now, I'm going to object that any such list is provided next week.
Well, we weren't provided.
The reason for the deadlines is so you all are prepared and equipped and have a management style and plan set forth that's reasonable. And obviously continuing this again to next week, giving more time, and just to potentially get another list. And what if 3,500 signatures are identified? And then you're stuck with the same thing. So I'm going to object to anything that hasn't already been submitted with line by line identification and specific reason.
Mr. Chair, yeah, if I may. So, obviously, Attorney Ash has the ability to object. That would be noted for the record. It doesn't mean the board can't proceed. Whenever a board is weighing procedural decisions, part of that calculus is whether there might be an appeal, in this case by the objectors or by the petitioners, and we can't predict that. I think this is really a balancing decision. As you noted earlier, we're kind of basing our process off of what the state does, but it is not required by law. And so, in my opinion, the board has the discretion to do that, but a court could disagree. So ultimately, it's a decision that just sits solely with the board as to what it feels is appropriate. I could add that where there was an instruction earlier to provide a line-by-line signature objection, the concept that Mr. Lynch and Mr. Kelly are putting forward is that every line should be challenged. And if that were the case, in my opinion, the argument to do that with is now, not to challenge every single line.
Right.
It's true, the letters that we sent said we anticipated that everything about the general legality of the petition would be addressed today, and then the signature challenges would be at the continued session. That is not binding on the board. If the board, and in my opinion, the arguments that are being made by Mr. Lynch, all of the signatures are forged or fraudulent, or a great majority of them, is a legal question, not a question about which signature is valid or not. So, in theory, another option for the board might be that the board would be willing to put off that legal argument to the next hearing date, and instead of, going line by line, allowing Mr. Lynch to present that kind of global challenge as a legal issue one time, with obviously the other objectors getting to weigh in, and Mr. Ash would also have the ability to weigh in on that.
Okay.
Mr. Chairman, could I just speak to that, please? So while it's fresh in your mind what she said.
I'm formulating something right now because I respect Attorney Ash's objections and everything like that, but this is an informal meeting.
Right.
And I want to be as open as we possibly can. So I believe more from a clerical point of view and management is that we can identify and make sure we're all talking about the same lines on there. Recognizing that we do have what we are going to call a global activity, I believe that should be heard today as part of the overall recall, because as it's law enforcement, there's legal issues and everything like that. We're not really looking line by line. It's a bigger issue at that time. So I would appreciate, we going into the discussion, because at 11 o'clock we have petitioners, which we will probably want to open up and swear them in and have a discussion at that time, trying to figure out how many questions might be posed to them, or they're going to make their presentation with their attorney, and then we might pose some questions to them. So my hands are tied a little bit in time-wise, but I believe that the global application should be presented as part of the recall package, and then we could coordinate later with the individual line by line, because that's the way the signatures are reviewed line by line.
Correct.
CMRs.
But we weren't provided with the numbered copies of the certified petitions in a timely fashion. So I just put that in to save my spot. I have no intention of doing 3,000.
Right.
I have a couple hundred maybe.
That's where I'm coming.
My original subpoena list was like 20, and then I knocked it down to like 5, I believe. And so I might be at the most 20. And I just want to get a sampling from top, middle, bottom of people who collected signatures to say, did you let people sign that weren't there in front of
I
you?
agree with you there that, we're giving you the time now until next Tuesday, or basically next Friday, to bring in documentation to say that,
Okay.
again, you have two parts, the global and the individual that you're
Right.
looking at. So you can discuss the global application for future discussions down the road with the signatures, but we can go from there, so.
Okay, so, all right, ready for my presentation? Can we
Yeah.
get rolling?
Mr. Chair, so can we just clarify? You're saying that you'd like to hear from Mr. Lynch or Mr. Kelly if he chose to argue the global fraud or forgery of the entire petition today?
It seems relevant
Yep.
at that time.
And then-
instead of the individual signature, how
Yeah.
it would apply to it, yes.
And then are you allowing additional time for the objectors to come up with individual signature lines? Ms. Keith already did that. Are you allowing, and Mr. Pasevich is arguing that he already did that, are you allowing additional time to identify
Additional
Additional
no.
challenges,
It's
no.
just housekeeping.
Okay.
We're
So-
coordinating and making sure it's clean. Like Steve said, I had one word change,
Yeah.
stuff like
Okay.
that. But no, we're just looking, because we already have a baseline
Yes.
that's been submitted. It's just more
Yeah,
housekeeping.
and to prove what I wanted to prove at that point, I could use the ones that Pam is putting in anyway.
And
to
yes,
prove the
and
point I
Mr.
wanted.
Chair, if I could just add one more thing. The other thing is, as Mr. Ash indicated, he said, "I object." And that's noted for the record. Again, if there was an appeal, there's an objection. So the board isn't going in that direction. But Mr. Lynch or Mr. Kelly, who've also made that global
Right.
objection, they can say that they want it noted for the record, that they object, that they aren't able to make additional line-by-line challenges. And that would also be
Okay, I object.
great. So now we're all on the same page, and it seems to me, Mr. Chair, that you could proceed with hearing from the legal objections from the objectors, starting with Mr. Lynch.
Mr. Lynch,
Thank you.
you're quite welcome, sir.
Okay. The most important component of our democracy is the election process. You go to the polls and you vote. To avoid the outcome of a free and duly conducted election by the recall process is a serious action. A recall is not exactly like an impeachment because there is no trial for guilt pertaining to a high crime or misdemeanor. However, the result can be the same. A duly elected public official can be removed from office. This is the gravest action in our political process. That is why strict guidelines set forth in our town charter must be adhered to. In this rare instance, our town charter takes precedence over state laws and even case law. There have been other recalls in our state, but they have no real bearing on this case. Our charter is the law. And for the reasons I just stated, the guidelines described in it must be strictly adhered to. I am going to read to you something from the Secretary of State's office who sent me an answer about an inquiry I made with them. This is from Michelle Tassinari, who is the Director and Legal Counsel of the Election Divisions of the Secretary of State's office. So this is a quote from her to me, and I have it right here for you to see, a copy of the email she sent me. It says, "This office is unable to opine on the process in Marshfield, including how the recall is initiated, the form of the affidavits or petitions, and timelines. As we discussed in our telephone call earlier this week, General Laws, Chapter 55B, Section 7, provide the timeline and process for objecting to a local ballot question. The petitioner's lawyer will try to lead you down the wrong path in your decision-making by regurgitating a bunch of case law that is meaningless in your decision-making process. The fact is, your decision needs to be determined by using your common sense and strictly based on the Marshfield Town Charter, Section 8-1-2. Your decision will set the standard for the future for recalls in Marshfield." So 8-1-2 I'm going to read you an excerpt from it, but I have the whole thing for you. I think you have it in your packet.
Yeah.
So it quotes, "The blanks," this is a blank petition right here. I had it in the packet, so I'm showing it to you. This is a blank petition. Right, so this was supposed to be issued with a raised seal and a time stamp, so that you know the distance of time that these have been circulated. It keeps the chain of custody in line. The words in the charter are there for a reason and should not be disregarded. The town stamp and time date make this document legitimate. It establishes a timeline. It guarantees the chain of custody. It legitimizes the entire process. For you to ignore the words in the charter would be a total disregard for our recall process outlined in the town charter. It's plain and simple language. It's not, you don't need to be a lawyer to read it. I'm a mechanic. I read it. I understand it, right? So let me just give you an example. I need this one back because it's the only raised. So this is what the town stamp really consists of. It's a raised stamp, and then they stamped their signature on top of it. That's how every one of these blanks was supposed to be given out to every person who was going to collect signatures to legitimize this piece of paper, and it wasn't done. None of them have this on it. I have all of them right there. Do you want me to give you all 206 copies to show you that they don't have?
I believe I have those.
Okay, so it does not have this on it, which is, exactly mentioned in the town charter. As you know, this is just our argument on the law and the process of the recall. I have here, so this is the global part, I have here the signed petitions. It's full of forgeries. And I don't mean just the occasional person walking into the supermarket who signed for their spouse or child. I mean a directed effort to sign other people's names by the hundreds. These petitions are proof of a massive fraud perpetrated upon the voters of Marshfield. Don't take my word for it. Here they are. You can look for yourselves. The forgeries are clear to any layman. It's clear and a purposeful pattern of deceit. That's so, and then the other people do fill in the rest.
Yeah.
So, and here is the copy of our town charter
Mr. Chair,
for you guys.
I actually,
You guys are making a decision.
Mr. Chair, if I could, I just wanted to say, and I am sorry I didn't say this right before we started, for purposes of this hearing, I propose that all of the previous correspondence, objections that have been provided be part of the record of this hearing, and that we will put together that record with a table of contents so that it's available, and if there was an appeal, it's very clear what documents are in the record. The other thing is that before we finalize that record, we would send it to each of the objectors and to the petitioners so that if they believe something else was relied on here, that they would be able to add that to the record. And that doesn't mean cases, it means substantive submissions. And if this is being submitted for the record, this is the, your statement, sir? Oh, this is the charter? Okay.
That's the bylaw.
Oh, this is the, okay,
town
it's the charter. We already have this in the record. Do you want it to be in the record again? Or are
I
you,
just wanted to,
just for their
them to
convenience?
see it with my
Okay.
presentation.
Yep.
And this is the email from the Secretary of State's office telling us that state law doesn't apply, that strictly the town charter determines how things are done.
Mr. Chair, I believe that is in the record, but if I could have one of those copies, and we'll add it to the formal record just in case.
I would like a copy of that email,
Yep.
if there is a copy.
And we will provide, if you don't mind, Mr. Kohler, if I could borrow your copy, that way we can provide one copy to the petitioners. And we're gonna label the other exhibits that we already just have relied on as 1 to whatever. These we'll do as starting with A, letter A, okay?
So that, Mr. Chairman, that wraps up my presentation. I just want to say, I think that is pretty clear-cut, black and white, and you could rule right now to reverse the recall. However, personally, I'd like to get to the signature part so that we can show that this was a clear pattern of trying to deceive the voters of Marshfield with this recall. But it's up to you.
I agree with you that we appreciate your presentation, but it's going to be an open meeting. Everybody's going to have
Yep.
a turn
Yep.
to make a discussion, and
Yep.
I'm sure there'll be rebuttals and other conversations or anything
Sure.
like that. And as we mentioned before in our last meeting, that we're looking at all the possibilities. The box is very wide and open, a big box to go
Yep.
play in on this, and we'll definitely look at the signatures at a later date
Yep.
and make sure to.
Not much play in the charter, though, it's black and white. But anyway, well, thank you for your time.
Thank you. Yeah. We're all doing this in good faith, definitely.
So, Mr. Chair, you'll move to the next submitter, which
Next
was
senator, Joe?
Mr. Pasevich.
Yes.
Actually, Mr. May, the next petitioner was Ms. Keith.
We went in the order which we received them. The list they gave me was you were next, but if you wish to,
Yeah, it's incorrect, because I
Okay.
actually arrived at Town Hall after Mr. Lynch and Ms. Keith had filed.
Okay.
okay. So if Ms. Keith would like to come up.
But I will be able to question the petition.
And I was going to mention that to Ms. Keith, is that at 11 o'clock, we have the petitioners are going to be online, and at that time, we probably should go to them, because I understand they have a particular window of opportunity where we are be here until, how late can we stay?
You can stay till 4 o'clock. I mean, technically, Town Hall is closed afternoon time, so.
I have some really pertinent questions for the petitioners.
Okay, we'll address it as we go.
Personally, I'd like to object to the petitioners getting their time wedged into my time, because I've been here since this morning and did not get to sleep late.
Time will be,
So I object to that. I have no formal statement prepared, and I do have some minor type documents here, but maybe you do want a copy. I did not think to bring extra copies because I wasn't thinking that they would be passed in as part of the record. But I want to call attention to the fact that we have the affidavit on the petition forms. In the opening sentence mentions that they're in the provisions of the Marshfield Town Charter. The charter is mentioned 3 times in the upper portion of that we're in it, under the town charter, provided by the town charter. We have the letter that, the sufficiency letter mentions the charter 4 times. The word charter 4 times, mentions the sections of the charter several times, that the letter is in accordance with the charter, provisions of the Article 812, more accordance with the charter and more accordance with the charter. Then we have this letter that was sent, I have 4 copies of this. It was sent by email, hand-delivered by the deputy sheriff, certified mail, and I think I got a copy from Town Hall also. Right away, starts that we're in accordance with Section 812 of the Town Charter. So we have a lot of obeying of the Town Charter. Apparently, the Town Charter is important. I also want to call your attention to this stamp from the Deputy Sheriff, a true copy attest. This is an attestation that this is a formal document, that it is a true copy. It's signed in ink by the initials by the person delivering and the date. And I gave legal argument in my written arguments that you already have, that that's what the town seal, the town charter is calling for the clerk's attestation on those petition sheets by signature and stamp. This is the type of thing, like, it might not be important to you. It's important to me when I see it. It shows me, wow, this is something formal. I know the courts would want to be looking for a seal like this, and lawyers also would put some weight onto a seal like that. I actually, Ms. Goldberg might not like this, but I actually did some looking into when I Googled your name, when I first heard of you, it comes up that she's done a lot of work, obviously, in this charter review. She does charter change, charter review with towns, and does a lot of work. She's been a town council in certain towns, maybe still is. She's worked from Amherst to Provincetown, all over the state. I would like to read, I I have what I label now an Exhibit B. So again, we can make copies of these things. I took some, first of all, she's done multiple towns. I won't go through them all individually, but Norton, Bellingham, City of Everett.
Is there a relationship of why you're,
Yes, no, I'm going to just talk about the charter, the work that she's done with the charter, and I just want to use her as a lawyer. This is things that's in the news that I was able to see, that the importance, the statement I want to make is that she and other lawyers, I wrote it in my legal argument, she and other lawyers have done work with towns on their charters, and I can find no evidence whatsoever of a lawyer recommending to remove the term that you should have the town's signature and the town clerk's signature and seal.
I don't believe that she's making that statement or that.
No, I'm giving you facts. The facts are that when everyone is reviewing their charter, they are often looking for language to remove, change, make better, or whatever. I cannot find any evidence of a lawyer, and I highlighted this particular lawyer just because she's here, that I cannot find evidence of a lawyer suggesting to a town to remove the requirement of the town clerk's signature and
I
seal.
don't believe she's ever taken that position, as far as I am aware of, and Dave.
I know, and I'm just telling you then, the point I'm making is that the requirements of the signature and seal are in all of these charters. They remain there. They have never, that requirement has not been removed. It is an important requirement. I also have a quote from Amherst that the Home Rule Charter defines the form, structure, and organization of the town government. Attorney Goldberg described the charter as the constitution of the municipality that takes precedence over local ordinances or bylaws, and in many cases, state law. So I'm trying to highlight the importance of the signature and the seal.
Mr. Chair, if Ms. Keith intends to submit that as an exhibit, the board can later determine whether that in any way affects its position on anything, but we would need a copy of it.
Yeah, I'm going to put these here, and if you want copies of anything I've said.
So let's just make sure we know which documents are which. So the first document that you referenced was the charter itself?
Well, it's kind of an oddball. Again, I gave 3 examples of how we are obeying the charter.
So that'll be B. All 3 of those will be B. Okay?
Well, I labeled this one B.
We'll change that. And then the next one is the news stories.
Yeah, these
That
are
will be
news
C.
stories, yes. I actually wanted to put you as my only witness, but I didn't do it. So
Sorry.
I put it here. You're my witness here on paper.
Mr. Chair, so we'll collect those and make copies and add them to the record and provide them to all of the parties.
Okay. So let's see, these, so I have my own written arguments, which, were lengthy enough, which you obviously can read, so I'm not going to go through it all. The charter is the governing law. I contend that the signature really meant to be wet, and the town clerk's office possibly has made comments about that. The attestation part, I'd like to highlight a law that I know Attorney Ash did not address in his arguments, which is MGL Chapter 4, Section 9A. I wrote that it requires the seal be affixed if expressly required by law. Section 9A is as follows. Any written instrument or recital that such instrument is sealed by or bears the seal of a person signing the same, or is given under the hand and seal of the person signing the same, or that such instrument is intended to take effect as a sealed instrument, shall be sufficient to give such instrument the legal effect of a sealed instrument without the addition of any seal or wax, paper, or the substance or semblance of sealed by scroll, impression, or otherwise, but the foregoing shall not apply in any case where the seal of a court, public office, or public officer is expressly required by the Constitution or by statute to be affixed to paper. I believe that law applies to this situation. We have the Constitution of our town, and this charter is considered law, and it is expressly written that it shall be attached to that paper. So I feel that that law is important. I have written about language and laws not being meaningless and superfluous. Let's see. I do want to highlight, too, that the 3 individual pages, the 50 batch that went out has absolutely no signature on it whatsoever. So I'd just like to remind people of that not only is there no seal, there's no signature on those pages, and I believe that those pages should definitely be overturned along with all the others. And then my final arguments were about adding to the certificate of sufficiency letter, which you've already, I don't know where we're at on that, but I don't believe that any signatures should be added there. So that's my legal argument, which you already have. And then I did take notes. I have notes that are in response to Attorney Ash's arguments. So I'm assuming that I can present those here, and they would be a document that you can have. I will try to make it quick, because what I did was I photocopied, I cut and paste basically something that he had written, and then in bold print are my comments underneath.
Just hang on for just 1 second. Let me just ask counsel.
When she's done, if people want to ask them questions, they can, and then Mr. Ash can make a presentation as well. But they get to, the objectors get to ask them questions. They would need to be sworn.
Okay, I don't know if this is a good time to recognize them.
Just let her continue until she's
Okay.
finished.
Okay. Sorry.
Okay, I think this is the end. I pulled out anything of my file here that, I can't remember though what I'm saying, because my head is just, there's too much information going on. The Attorney Ash mentioned that it was just a comment on the $7 million override being maintained by the petitioners as being necessary, and I write that it's not necessary, it's impossible, and the warrant was made to show that there was no need for it this year. As far as the actual petitions go, he highlighted in bold print that 3,877 verified and certified signatures were collected, and he's highlighting the sufficiency letter. He states all procedures were followed as outlined in Section 812 of the Town of Marshfield Charter, stating that these petitions were put out that way. They were followed. I wrote all charter procedures were not followed. Date, proper signature, and seal were not on the blanks. The town's clerks reported the 3,877 signatures, stating that Precinct 4 needs 461 and only received 486, which is 25 signatures over. I said that I have written, I say there are more than 25 forgeries related to Precinct 4, and the excess will cease to exist if the registrars review the signatures as required by law. Attorney Ash writes that the volunteers actively collected signatures on a daily basis in their neighborhoods in accordance with all town laws and ordinances. I wrote that volunteers violated state law, MGL Chapter 5611, which governs unlawful signing, and ignored the warning, which is in capital letters, very small print, but capital letters for the word warning, on the back of the petition, noting a possible $1,000 fine and 1 year in prison. Attorney Ash writes that he highlights, he does not like some of my case law. He highlights a case, Robinson versus State Ballot Law Commission. He states that the lack of the seal is minor and the defect needs to materially affect the validity. He goes on to highlight from that case that affecting validity, one of the things on the list, undermining the chain of custody, violation of a condition of a statute, which we have here, affects validity, but also undermining the authenticity of something affects validity. That case helps prove my point, if you ask me, the Robinson case. I say that lack of attestation is not a minor error. It's mandatory, and it undermines authenticity. The Robinson case was about photocopied, paged upside down, not really apples to apples comparison with our town. Attorney Ash writes that further the pages have been adequately certified. Let's see. Petitioners maintain this petition must be distinguished from the affidavit, and further that the pages have been adequately certified. I just wrote that the point, he does not like my use of the Winchester case, and I wrote that the point of the Winchester case is that the court ruled it was not good enough it was about an affidavit, which I realize a petition is not the affidavit. But the Winchester case point that I was making was that the court ruled it was not good enough to submit a statement, which is what the people did, and call it an affidavit. The statement had to be written with the quotation under the penalties of perjury. They, again, have to go through a formal procedure to make it an affidavit. You have to attest or go under oath that you're, under the penalties of perjury. So the act of attesting to the truth and authenticity of the affidavit had to include this formal technicality. So again, our town seal is important in the same way that the Winchester case, looked at that detail. Attorney Ash does not like the Commonwealth versus Shaw case that I use, and he writes that the case has absolutely no similarities. I state that the case does have similarities, and that the pages in the Shaw case were defective and were ruled that they should not have been admitted. They were not signed and sealed properly. It was a batch of like 9 papers. 5 of them were attested to properly with signature and seal, and 4 of them weren't. And even though the person eventually lost their case, overall, the determination was made that the 4 pages were not proper pages. They were not attested to properly. They did not have the signature and seal on them that was required. So that case applies. And as far as the IRS case, which Attorney Ash did not like my use of, I wrote that he doesn't make a comment for why that case is no good. The IRS was found to have violated the law that required mandatory proper attestation, just as Marshfield's charter requires the town clerk's seal. It was the same type of thing. The IRS had put out some type of summons that by their own, the laws were that those summons need to be stamped, signed, and sealed correctly, and they weren't. And the court very quickly, I'm surprised, because it's like a federal case, the court very easily said, you didn't follow the laws, the seal and the signature aren't there, and you didn't follow the laws. We read the law, and it says shall, and shall is mandatory. So that was the IRS case, so somewhat similar. I did pick up on, I questioned the facsimile stamp being used for the registrars and saying that there were 3 people involved in, the 3 names are on the stamp, but 2, in the town clerk's sufficiency letter, it states that a majority of the board signed. I took that to mean 2 out of 3 and not including the town clerk. So I questioned whether 3 registrars signed these forms the way the law states that 3 registrars. So that's the only procedure that's listed in 950 CMR 55, that if you, item 7, which is the 3 registrars signing, if you don't follow that procedure, you are, that can invalidate your work. I question whether that procedure was done. I would need to ask questions to know, and I thought one of the other objectors had some of that. I'm not sure if Joe has some of that in his work. And then my last thing, I touched back upon the adding in of the signatures. I said that because Attorney Ash said it was unclear. I guess he wrote it's unclear at best what I was saying when I said signatures should not be added to the sufficiency total, and we've already addressed that a few times. I state that after once the town clerk's letter is written, the next administrative step is triggered per the charter. The 15% threshold is only documented in the official letter and must stand as the official record. So to me, that's what we're objecting to, is that official letter. And there should be nothing else to object to outside of that after that process date was ended. And petitioners state that the defects be applicable. They are merely clerical. And I wrote evidence of, this was a note to myself, evidence of non-clerical, a true attest copy letter hand-delivered by the sheriff, which I already showed you. It's not a minor thing to be attesting to things properly, and it's required by law in certain cases, and this is one of those cases. And I would like to remind you again, I know there are lawyers in the room, and maybe they have an argument with me, but that law, Chapter 4, 9A, also That, I know that Attorney Ash did not seem to address that in his letter, so I don't know whether there's an argument to that, but I contend that that law applies, and it states if it's written in law that you apply the seal, then you apply the seal. So those are my, kind of a recap of my arguments, and these papers are now, these were connected to each other as kind of one example. So I don't know if you want to keep them connected that way.
Yes, go ahead.
Mr. Chair, that final, those statements made by Ms. Keith, does she intend to have those entered into evidence, or was that just used for her notes? If it's into evidence, we would need a copy, and it would be Exhibit D.
That's, I have them right here, you can have them. They were kind of intended to be notes to myself, but they're not, there's nothing in them that's,
That would be up to Ms. Keith.
Yeah, we would accept the documentation
yeah, I'm fine with that.
as you presented. Thank you.
Do you want to, should I work
give
with
them to
them to
Mike.
copy these?
So, Mr. Chair, I believe that, as was indicated earlier, that the petitioners, the lead petitioner and the other identified petitioner may be present.
Yes.
And so the question really is, essentially, we know that Mr. Lynch asked to ask questions of the petitioners. So,
Hang on for a second. Hey, Dave,
Yes.
can you mute your phone?
Did I move? No, I didn't touch my phone.
Can you touch your phone, please, and put it on a mute? Because we're getting a lot of squawking here, and it's getting louder and louder, so I don't know what you're doing with your toes.
No, I haven't moved, but I will mute, yes.
Thank you.
You're welcome.
So we have two other petitioners who haven't, two other objectors who haven't been able to provide their arguments. Before we turn to the petitioners, would it make sense to find out from those objectors how long their arguments might be? If they're quick, I think perhaps doing them first and then going to the petitioners versus having it interrupted might be appropriate.
Because the petitioners have arrived in the room here in person, and we thought they were coming in via electronic.
I thought I made it clear, Mr. Chair, that they were available in person to be.
And they're only here for 1 hour? There's no way that they can extend because the other people have been here?
I don't know how long the objectors have
We could find that out, but I mean,
Mr. Chair, I'd suggest asking the other two petitioner,
Right.
objectors how long their arguments might be.
okay.
I think I'll be less than 10 minutes.
Okay. And Eric?
I don't have anything more, but I would say, just for the purpose, maybe reserve that right for a future date, if possible.
Okay, I didn't quite hear.
Mr. Chair, he indicated that he might reserve his right to make
Okay.
opening arguments. So if Mr. Pasevich can limit himself to 10 minutes, it would seem appropriate to go to him and then come back to the petitioners.
Yes.
It's my understanding all opening arguments and legal arguments are being made today.
Mr. Chair,
Sure.
let's move forward.
So with respect to that request, that's
At this time, we're going to, because Joe has been sitting here for a while, and I had the understanding that it was going to be by video, and they did show up in person.
Okay.
I think we should honor the people that have spent their morning here already. We respect, and it is an informal
Yeah,
meeting.
the
and
people that have
we're
the
gonna
burden
be
of
as
proof
fair-
have been sitting here all morning. Yes.
That's true, you
Yes.
have.
My
and-
clients are here without subpoena, willingly.
And there's no reason
and the-
to get into a
and it's
discussion.
my understanding that they don't
Joe is
actually
going to
need to be
be his 10 to 15 minutes, and then we'll allow you to come
And that
up.
I will advise the clients that if they need to leave, they're free to zoom in.
Mr. Chair,
Probably not, sir,
Mr. Chair, if I
because
may.
they're here because they have to be sworn in. Yes.
If I may, I had understood Mr. Kelly's comment to mean that he was willing to wait until later
Exactly.
today.
Right, yeah. It's-
Okay.
Joe Pasevich. First off, Mr. Chair, Mr. Registrar, and counsel for the registrars, thanks for doing this and for your patience and breaking new ground here. I first want to be clear, when will we get a chance to question some of the people? Like, I'd like to ask the town clerk and the registrars themselves some questions about the process. When would that happen?
Mr. Chair, if I may. So the registrars are the judge and jury for this purpose, and so they cannot be questioned. Certainly, we can hear from the town clerk after we deal with the opening statements, and because the two petitioners who are here not pursuant to a subpoena but on their own volition, it would be appropriate, in my opinion, to move to them after this. So that would be my response.
Well, then I'll just reserve my right to eventually get answers from the registrars, since they were integral to the process of doing this. And my question would be, and I want to reserve this for future responses, what exactly was the role of the registrars? You know, how much time did they spend in the office, and what did they actually do? With regards to the town clerk, I want to call attention to the letter of sufficiency dated April 21st, where it makes a reference in the third paragraph. Petitioners have, quote, have satisfied the requirements for recall of Select Board member Eric Kelly by collecting in excess of 15% of the voters in each one of the precincts. The problem I have with that is that there's no numbers given here. There's no number of, since this is the official record certifying or a sufficiency of signatures, they do mention 3,877 verified and certified signatures, but there's no reference to the voter base. In other words, how you got that 15%. And we know the voter base does change. Even if you go to the RMV, you're an automatically registered voter, and towns are constantly getting updates. So this letter is invalid, and because of that alone, this whole recall petition should be thrown out, because there's no documentation of the voter base. My next point, I asked for the preservation of records, and I also want to reserve the right to get access to records that I have already asked to be preserved. That includes videotapes taken from Town Hall, because I will certify and I will swear that I witnessed Lara Brait, one of the petitioners, in the clerk's office during this process. And I want to know what she was doing there and what influence she might have had on the process. As far as the use of the seal goes, I just want to assent to and assert my agreement with Ms. Keith and Mr. Lynch about the use of the seal. That's a good question. Why wasn't the seal applied to this petition? I have which I have submitted to the town clerk, a photograph of the petition from last year's recall effort that includes what appears to be a town seal on it. And why wasn't the seal applied to this round of the recall petitions? To me, is a very relevant question. Well, I think I know the answer. If you look at the petition sheets, the length of the narrative or the text on the most current recall petition is much longer. Not much longer, but longer. Longer enough to make no room for a seal. So the clerk, instead of applying the seal, which should have been done, just said, well, I don't have room for it, I'm not going to put it. That's not an excuse for not affixing the seal. And I agree with Ms. Keith's arguments with regards to the seal creating a validity and an absolute necessity. And as Mr. Lynch and other people have said, the process is everything here. This is probably your first go-around, maybe your only go-around on a recall petition hearing. And you have to use this opportunity to set the standards. This is where it all gets laid down. And you cannot shirk that responsibility. Please don't. I think that's why it happened the way it did. Again, it's not an inconsequential thing. That's pretty much it. Those are the main things. I want the records preserved. I want to reserve my right to question the clerk and to get answers in some form from the registrars, because again, I don't know. I know it's a unique position to be in. I appreciate that. But somebody has to account for how this was done and how it's going to be done in the future. Thank you very much.
Thank you. Thank you. Thank you. Attorney Ash?
Good morning, members of the board. I'll give a brief opening, and as we're all aware, my clients, the petitioners, are here to answer questions as well.
Okay, and prior to that, should we have the petitioner sworn in at this time?
Whenever you're ready.
It might as well do it right now.
Can you guys please, do you swear to tell the truth, the whole truth, and nothing but the truth, Officer Dodd? The recall petitioners are sworn in.
Thank you. As I have sent and served with the board, our formal opposition, I represent Laura Brait and Sean Costello, the petitioners in this matter. I do not believe that much background is relevant for purposes of the board's decisions here today, but just to address some of the comments that have already been made by the objectors, this is not the first recall petition against Select Board Member Eric Kelly. So a lot of this, I assume, does not come as much of a surprise. You all live in the town, of course, you know the issues and the arguments. You are tasked today with deciding whether the objections made to this recall petition meet the burden of proof, which state that you are to certify signatures pursuant to 950 CMR 55. 950 CMR 55 states that registrars must certify petitions unless specific disqualifying conditions exist. Most errors, therefore, are simply clerical and are not disqualifying. 950 CMR governs the certification by boards of registrars of voters, names on all nomination papers, and petitions for ballot questions and recounts. 950 CMR shall be interpreted to achieve and maintain accuracy and promote the right of eligible voters to sign papers and petitions. I've also cited for the premise that the objections must show that the defect materially affects validity, the case Robinson versus State Ballot Law Commission. The four objections that you have in front of you, seemingly from, collectively from the objectors: lack of the town seal, lack of issuance date of the petition, failure of 3 registrars to sign the petition, and the signatures should not be added to the certificate of sufficiency tool. We've addressed some of those informally in the beginning of today. It's my position that even all of those, if all of those 4 issues were proven to have existed and to be against the petitioners, the burden of proof is still not met. 950 CMR gives you outlines of exactly how to and what needs to be certified, and I do believe that this was followed in the case. The only petitioner to, which I appreciate, and I also appreciate that Ms. Keith almost did, covered a lot of what I had to say to you all already, but the only objector, I'm sorry, to provide case law and statutes was Ms. Keith. She has provided 3 cases which I differentiate in my papers. She's also this morning alluded to MGL chapter MGL 9 4A. It's going to be my position and our position, and hopefully the position of the board, that your town charter controls here, and that you are to abide by your town charter, which I believe that you all did. With respect to the other arguments that you just heard, I would like just to note with an email that Mr. Lynch stated from Michelle Tassinari, she's the first Deputy Secretary, Director and Legal Counsel, Elections Division. Whether he meant to misquote Ms. Tassinari or not, it seemed like the closing of his argument could have perhaps been part of her email, and I want to maintain and differentiate those two. The last paragraph or so that Mr. Lynch stated, with all due respect, was not part of Ms. Tassinari's email. Ms. Tassinari's email, you all have it. It is very, she's not giving him legal advice. She's certainly not implying that the Petitioner's Counsel is going to make up lies about case law, as what I believe was the closing of his argument, and certainly I want to maintain that that is not in this email, whether unintended or not. And with respect to Ms. Keith's arguments, I don't think that the lack of removing the requirement of a seal from a town charter has any bearing on this board. I do provide case law and some background in my papers. I know you've all read them, and as stated, the petitioners are here to answer relevant legal questions related to today's hearing and related to the objections. And with that being said, I'm happy to advise them to come up here or wherever the board would like.
I would probably request that they come up and join you at the table so that, and we don't have a mic on the back stand, but so that the individual questions can be posed.
Mr. Chair, if I may, just in terms of how this would go, we should go in the same order that we did with the testimony from, or the legal arguments. And I just remind you that this is an informal hearing, and the purpose of the hearing is to get relevant information. You have the ability, if you feel it is appropriate, to stop a line of questioning and, to require a certain level of demeanor, not insinuating that it would not be polite or on target, but just as a reminder for the process.
Sure. And as legal counsel has just indicated, this is an informal meeting. We're here to gather information. I'm not going to be asking questions at this time or things of that nature. Right now, we're just opening it up to the public because they had indicated during their testimony that they had some questions. And at this time, I would recognize Steve.
Thank you.
Mr. Chair, if I could, I'm sorry, excuse me, Mr. Lynch. We're not really opening to the public, just to the objectors.
sorry.
Yes, thank you.
Public in attendance right now, yes.
So I have a question for the petitioners, each one individually, if they could both answer individually. So do you have the names of the 20 people that you said you gave out the blank petitions to collect signatures? Could you provide us with that list, please?
If you have the names of all 20 people, you're free to give the names if you know them off the top of your head. If there's a document production request, then I can address that with you after.
Sure. So I do know some of the names, but also what I need you to realize is that I had given out petition sheets to a specific person, and then they knew other people that they also passed them out to help collect signatures. So do I have a written down list? No, I don't. Could I give names of people that I gave petitions to? Yes. Do I know who every single one of them are? No.
I received some requests as well from folks when they saw that my name was one of the two petitioners in order to receive petition sheets. I dropped a couple sheets off to a few different people. I'm happy to give really only a couple names, but essentially what happened is Ms. Brait had taken on the burden of organizing those volunteers, so I would reach out to her if I heard from somebody who wanted some petition sheets.
And I believe that is the relevant answer to Mr. Lynch's question.
Yeah, well, we'd like to see the chain of custody, so we'd like to know who was collecting signatures. And it would be nice to know which numbered sheets each person was responsible for collecting the signatures on.
I got to ask legal counsel right now because this is all part of the recall activities associated with it and how the relationship and everything like that. So the responses to Mr. Lynch's questions and anybody else's questions should become part of the record right here. So we would request you to develop that documentation and provide it to us so that we have it as part of the records. I believe that would be appropriate.
I maintain that that's irrelevant to the board's decision today as to whether you meet the burden of proof of certifying the petition.
I believe the burden of proof is left to the board, the three members right now. I mean, this is our first time going through this.
Sure.
I do not wish at this time to have to recall these individuals to say, oh, we need to look at it again on now. I don't know if they knew that the 29th is another meeting that we're having, and they can attend at that time too. But again, we'd like to have as much documentation as possible. The relevance will then come from us. We'll make that determination. I understand that you're protecting your client's rights and everything like that, but I believe it is a legitimate question because of the largeness of this activity and where it could go. There could be so many tangents, and we want to keep this as open and fair as possible, and I believe it was a fair question, and we would request that.
Okay.
Mr. Chair, if I may as well, I think the question was requesting the names. So the witnesses indicated that they do know some of the names. They may not know all of them, but if they do know them, they can answer that now. What they know.
I was giving them a chance to put it down on a piece of paper, sign their name, so it becomes a legal document.
Okay,
Instead
understood.
of
Yes,
having a piece of paper with names on it.
If the board finds that that is relevant, necessary information, then I will work with the petitioners to provide that document to you.
As the chair, I'll take that obligation and say, yes, it is relevant.
Okay, thank you.
And then my next question would be, the people that you gave these blank sheets to collect signatures, did they turn them into you and then you turned them into the clerk's office, or did they turn them in directly themselves?
Well, we can start with Ms. Brady.
Sure, both.
Both as well.
And would you say, do you have an idea of how many of the blank petition seats that you personally stood out and had people sign? What percent, we would be 50%, 75%? I mean, how many of these sheets did you personally watch people sign their name?
I'm not going to advise them to guess that number.
The estimate?
I don't have to guess either.
Yeah. I probably only won because I only witnessed my family sign the sheets. I wasn't personally standing out collecting the signatures.
Same here. I got my family to sign, for the board to know that I was actually on vacation for more than half of the time that the signatures were collected. I was in Washington, D.C. But I did get my family to sign, and that is the only signatures that I collected.
So virtually all of these petition sheets that you took out was left to somebody else, unnamed people, to collect the signatures?
Can I answer that?
Sure.
Yeah, there
I
was
can too.
quite a groundswell of people in the community who wanted to get involved and collect signatures for this effort.
And did you,
Yes.
did either of you explain to the people that you were giving these blank sheets to collect signatures, the law regarding if you could sign someone else's name?
Yes, in anticipation of exactly what's happening right now, I was very clear, please do not have anyone sign for anyone else.
And I had directed the same when folks would reach out to me and we'd speak about it. I would also direct them not to sign for anybody else and to ensure that nobody else signed for anybody else. I've been collecting signatures for 20 years as a volunteer for campaigns and for myself as well. That's 101. We know not to forge signatures.
So neither of you personally know of anyone that signed someone else's name on any of the 216 petitions that were signed and certified?
Correct.
I do not.
And you're telling us that under oath, right?
Correct.
Okay. You guys got any questions for them?
Yeah.
Joe? Okay.
You all set, Steve?
I'm all set, thank you.
Yes, okay. Ms. Keith, you have any?
I don't believe I have any more questions now.
Okay.
I had the same question, especially
All right.
getting a list.
All right. And I would recognize Joe, Mr. Petrovich.
Hi, Joe Pasevich again, Wilson Road. The language, the text at the top of the petition, do we, I want to ask the petitioners, do we know who wrote that? Did they author that?
I did.
Lara wrote that. Lara Braid wrote it?
And I provided insight through that process as well.
Okay. So it wasn't written by the clerk, it's not a template. You fully responsible for the content of that.
Correct.
Correct.
And the
Stand by it
content-
as well.
And the content is based on, well, it's basically testimony that Mr. Kelly has done this, that, and the other thing, certain things. It includes the assertion,
Mr. Chair, if I may.
Sure.
I just want to point out that the board has no jurisdiction over the content of the grounds for recall that were stated either in the affidavit or in the petition. So Mr. Pasevich should at least try to indicate why this is connected to
The relevance?
the relevance of this discussion about legality of the petition, not the content of the affidavit. That's for a court.
I understand, thank you. It goes to the point of how this was presented to the public. And I want to ask the petitioners if they believe that an individual obstructing someone from voting in general, would that be something like a civil rights violation? Would that be a real big no-no? Do they understand that obstructing and keeping someone from voting is a civil rights violation in general?
I'm not going to consider that question relevant.
I'm not following the relationship of somebody voting versus somebody signing up.
Well, I'm trying to make a point. I'm trying to get to the point of how this was presented. And how it was presented has a lot to do with the message, okay? And the message is relevant here.
I agree, but I believe the questioning that Steve had posed to them, how they presented it and what they said, or how they interacted with the collectors, I guess is the best way to.
Well, then it's relevant, because why wouldn't they just then create a petition that says, do you agree to remove Eric Kelly from office? Period, end of
It's
statement.
not relevant, because that's up to the petitioners to develop that criteria, and then it's up to the town clerk to process it the proper, within the regulations and things of that nature. So the wording of that text, just like the legal counsel mentioned, that's beyond the scope of what we're looking at right here. We're just looking for the validity, and I'm sure if it should go down into another court arena or something like that.
Yes, Mr.
that's where
Chair.
the discussion goes, so.
But as stated in Mass General Law, Chapter 268, Section 1A, quote, "This affidavit is made under the penalties of perjury, and said affidavit states the grounds of removal as follows." So they chose to state under perjury the reason why he needs to be removed.
Mr. Chair, that stands for itself. There's no, they signed under the penalty of perjury. If there is a violation of law, that would be for a court to decide, and in fact, that would be a criminal court that would make that decision, not a superior court.
Yeah, that's beyond the scope of what we're here for.
How does, my next question was, again, it's sort of a follow-up to the previous objector, is that how, if these people never participated, they left it up to other people to collect these signatures and never actually participated and interacted with the signatories, the people signing this, how do they know that there wasn't fraud or deception or misleading statements being made? Because I can testify myself that a person holding a petition basically acceded to my question that Mr. Kelly was violating everybody's civil rights by not allowing people to vote, period. And so therefore, I was allowed to sign the petition. I was encouraged to sign the petition. So how do they know that there was no fraud?
I believe they don't have to prove the fraud or nature of that business. You've collected a lot of signatures. I have collected a lot of signatures over my time and everything like that. You approach people and ask them, and it's up to the individual that is signing it to read the document, to understand what they're doing, and understand the penalties associated by. So the onus is really on the signature or those that are signing the document. That's not for us to do. That is law enforcement.
Okay.
If we do find that there is fraud, and under the provisions of 19 CMR, there is a way that we can then put into law enforcement to ask them to investigate. And if you have other information, but that's all outside of the purview of what this board is looking at right now. We're just, you have an opportunity now to.
Okay, so now I want to ask a question that goes to motives. In being here and participating in all this, I want to know if Ms. Brait and Mr. Costello believe that Mr. Kelly is preventing just unilateral. No, I'm going to their motive, not to petition.
This is not motive. We're here just to find out. You have very specific. The motive to me is more in a criminal case. If you find that there is fraud associated, we cannot make judgment as registrars on their motive. All we can do is what is detailed in front of us. The language that they have there is we have to stand on and go forward. So.
But Mr. Chairman, they're defending this. They are defending this instrument.
Mr. Chair, if I may. First of all, even though this isn't a court of law or a formal hearing, people can testify to things that they didn't experience personally. And they've both said under oath that they're not aware that anybody has committed fraud or forgery, and that they gave explicit directions not to. So to me, that's been asked and answered. And it's also outside of their experience. They've testified to that. So again, I think at this point, that's really irrelevant. I think we could move on. Their motives, as you indicated, they signed under the penalty of perjury an affidavit that says what they think. We know that that's what they think. And, I think the question is there other things relative to the collection of signatures that he believes they have personal knowledge about that they could provide testimony on? And that really would be it.
I appreciate that, Attorney Goldberg. I think asking this board to make a decision on affidavits or some kind of, I think you'd be really rewriting the Constitution, quite frankly. I mean, in this line of questioning is exactly The reason why I have relayed that they are here to answer specific questions that the board deems necessary by and through the objectors, of course, to establish the burden of proof.
Okay, well, let's go to the process then. I alluded earlier to the fact that Ms. Brait was present in the clerk's office during this process. I'd like to know what she was doing there.
Is there a question?
Yeah, what was she doing in the clerk's office during this process at the time she was there?
What was the date and time?
On or about the, let's see, 7th and 8th of April.
If you know the
I
answer,
can-
if
yeah,
you know the answer,
that's
then
fine.
you're free to
Yeah,
answer.
sure, I can answer. I've never been involved in a recall petition before, so I had a lot of questions, and the clerk's office was very nice in answering my questions. I wanted to understand the process and how it worked, and as the process went on, I had more questions, and the clerk's office is pretty busy, so sometimes I had to wait, and sometimes they did let me in. I went in more than once, so he saw me once, but I was in there more than one time. I had asked about how they verify the signatures and what that process was, and they did share with me that they checked the voter registration, because at one point I had referenced that my voter registration is different from when I got married. So my maiden name is Prakop and my signature is Laura Prakop, but I signed the petition Laura Brait, but that still is, that's me. So I was just asking questions in reference to that, just to understand the process.
In the process of distributing this to the various gatherers that's referred to earlier, did either of the petitioners in any way utilize school bulletin boards, emails, or other ways of communicating within the school district to encourage or solicit or recruit people to do this work?
Absolutely not.
Are the petitioners aware of any communications being used within the school district, chat lines, email threads, et cetera, to publicize and encourage this process?
No.
Is that no? They're saying no?
That was a no, that part.
So they're not aware of anything used to publicize this process. Was the superintendent of schools consulted on this process?
No.
Prior to the issuance of the petition?
I don't see how that's relevant.
Yeah.
Pardon?
I don't see how that's relevant.
Sean indicated no, so your question was answered, but I don't understand the relevance of the superintendent of the school being involved, but he still responded though.
Well, it goes to the question of like who did the work, because we know they didn't do the legwork, but they did have something to do with writing this, which I just want to make a final, take it for what you want, is that it was stated that Mr. Kelly in no way stopped an override vote. He's doing what he did under the powers of the selectmen, that a select board member has.
Okay.
So I know you can say this is the content, it can be anything, you can say you wear a pink tie and we don't like
Exactly.
the way you talk. But at the same time, when it's egregiously slanderous
I agree,
and
Joe.
incorrect,
Yes.
there needs to be some level of standard
Again,
applied.
it's outside
Thank
the
you.
purview of our requirement to review that and accept that. It's up to the town.
Yes, Mr. Chairman, I understand the legal side of that.
We're just trying to keep it focused on point.
Thank you.
We appreciate it.
Thank you.
Thank you.
Eric, do you have any?
Thank you, Mr. Chairman. Could I approach and ask and see if this sheet is the one Laura Brait had filled out? Is the only one that she had filled out?
I didn't quite catch your question.
Could I approach
Oh.
the petition sheet
You-
to verify if Laura Brait, this is the sheet that Laura Brait
Yes.
had gone out to get signatures on?
Didn't recognize the form or not.
Is there a copy of this?
My copy.
That's my name.
So the question, I believe the question is this the sheet that you signed and turned in?
I signed that sheet, yes. Did I turn this one in? Oh, no, I turned in a million. I mean, what is that?
So the record would show that she acknowledged signing this, but that she doesn't know whether
didn't
she
say
turned
that.
it in. That's, no. And we're gonna mark this as Exhibit E, is that correct? Yeah, Exhibit E.
Oh, okay.
Yeah.
That's fine.
So that
I mean,
was, your question, Eric, was, that's her signature, she verified that that's
Yeah.
her signature. She does not recall if she turned it in personally or dropped it off.
But is she, her signature's on, but did she collect the signatures that are on them?
She
No, I didn't say that.
oh, okay.
I signed that sheet. There's other signatures on there. Did I collect those personally? Is that the
I
question?
believe that's the question.
Well, the second one's my husband. No, I know exactly where this went after it was to me. Is that the question?
Eric is asking the questions. I don't know if that's the question he's posing.
Yeah.
She signed is the one she collected signatures for and turned in. Ask her if that's the one.
Well, I think she already answered it, Steve, to be honest with you. She's already on the record. I don't have to rehash it, in my opinion.
I don't understand.
Is there a question pending?
We're working that out right now, if there is a
I
question.
have one question. Can I ask?
To assist Eric, please.
Mr.
Yes.
So when I was asking questions aloud, she said that she signed one sheet and turned that sheet in. Is that the sheet that you had signed and turned in? Unless you signed it more than one.
No.
I believe her response was no.
The
she
response
doesn't-
to Eric was no. The response to me was that she signed one sheet, collected the signatures, and turned it in. Is that the sheet?
That's not what I said.
I believe, if I'm not mischaracterizing the testimony, it was that she turned in multiple sheets, that she collected one sheet. It looks like that particular Exhibit E, I believe, is dated April 8th, and there was just testimony a moment ago that Ms. Brate was at the clerk's office on April 8th, so that she probably turned.
Only collected one sheet of signatures, she said. When I
That's not
asked
what I
her.
said.
Is that the sheet?
Can I talk? Yes. Collected one sheet of signatures. Do you mean collected sheets that I brought? Can you let me finish, please, Steve? Thank you. Okay. Are you asking me if because you're saying collected one sheet. I collected a bunch of sheets. I think you're confusing collecting signatures and collecting sheets. Can you be specific about what the question is? Are you asking me if I collected one, like you're saying, you said you collected one sheet. I collected multiple sheets. I only collected one sheet of signatures that was me and my family. Can you re-ask the question, please, Eric?
So is that the sheet?
Yes, I signed that.
So you collected all the signatures on that sheet?
I did not. No, I did not collect all the signatures on that sheet. I collected mine and my husband's, which is my family, which is what I said. I did not collect all of those signatures on that sheet. I gave that sheet to someone else, and they collected signatures.
Who was that?
If you recall who it was.
Janet Gibson.
Okay.
Does that answer the question?
It clarifies it.
Okay.
So, Eric, do you have any other questions?
I do, Mr. Chair, thank you. It was requested to get names of the petitioners who received the blank petitions. I believe Laura said that she could provide those names, but it's to my understanding, Laura said that the people that she personally handles petitions to probably handed more petitions to other people. So I guess my ask is, whoever she handles petitions to, sounds like we can get names of those people, but I think we're gonna need the names of the people that also received the petitions after those people received them, that handed them out to others. So I want to know if that's going to be a possibility as well.
It might be a possibility through another venue, but right now I believe we honored the first setting of distribution. So the first group of distribution, because then you're getting down past a second chain of control or something of that nature, could go into multiple people and areas. I believe the best thing for you would be getting a list of the primary.
Yeah, we already asked for that, yes.
And I think that's fair, but going to a secondary or a third level of distribution might be beyond, definitely be beyond the scope of what we're having here. We're giving some leeway here, but we do agree that it's best.
I mean, my opinion, Mr. Chair, is I don't think we're going beyond the scope, in my opinion, because we're going to get a list of people that were the primary people to receive the petitions. That's good, but the whole thing is that where there are concerns in regards to the petitions and signatories, I think, I believe that the initial people, the primary people that received them, but then handed them out to others to get, I think would be important for us to get those names on record as well in regards to who else was out there collecting signatures.
I believe we're probably gone beyond what our normal level of activity is, requesting these names for the primary. I'm just thinking out of the box a little bit, and again, I can't predict the future or how things are going to go, but you might get more into a legal issue and law enforcement requiring certain things, maybe some type of subpoena or some other activities that requiring people to testify under oath, and that's way beyond our scope. Our scope right here is the for validity of the recall itself, and then the signatures. How they collected the signatures and things of that nature, that's definitely way outside even our CMR activities right there, and that would be more of as objectors getting into an area where you would have to hire legal counsel and possibly get in law enforcement involved for whatever it is, Secretary of State's, I don't know, that's not my domain at all, but I understand where you're going. I can't help on your activities right now to get to that level. I'd be willing to go to the first level of they spreading it out, recognizing that they have a 21 days, so they probably have a list of people that they're going to immediately to get it out, and that's usually the way the collection of signatures occur. But beyond that, I might be speaking out of turn. I can ask my legal counsel here if I am gone way far.
No, Mr. Chair, this is well beyond what
Yeah.
would be anticipated, and if there had been a request for some sort of information pursuant to a subpoena prior, these are legal arguments, and they would have had to have been made today.
Yeah. I can see some relevance of getting the first primary, because then it has a relationship to certain ballot or petitions that have been signed. And then you have an idea to support your position, as the Attorney Ash says, the burden of proof. And burden of proof is on both sides. It's just not on the objectors. For us as registrars.
Well, I
we have to
disagree,
look at
Mr.
them.
Chair. I think the burden of proof is on the moving party.
Mr. Chair,
You can discuss that with Attorney Goldberg.
Mr. Chair, I think we're getting
Oh, yeah.
farther along than is appropriate.
I will
we
say,
have-
just for time purposes,
we have
it's
two-
10 of 12. So if there are any further
Mr.
relevant questions.
Mr. Chair, if I may, the question of burden of proof, et cetera, that's a legal issue. That's not for people to weigh in on. That'll be a decision of the board. And, I think at this point, we should go back to whether there's information that Mr. Kelly seeks to find out from these two petitioners, and keep it focused.
Focus. Eric, you have any more questions?
Mr. Chair, I appreciate it. I understand the position you're in. Look, I asked, I got it on the record. My opinion is that there are concerns in regards to the petitions. It appears that you're providing or requiring the petitioners to provide the names of the primary people that they handed the documents, the petition documents out to. In my opinion, I don't believe that should exclude those that were beyond those primary people that they hand them to. I think they're also probably going to be important in this, but I got on the record, you made your decision, and I'll respect that and leave it there.
Thank you.
It was asked of Lara in regards to her being in the clerk's office, and I believe that Lara asked about voter verification, and she was making the, using herself as an example in regards to her being married. I was just wondering why she would specifically ask about how the voter verification is being done in regards to signing these petitions.
I don't see the relevance to the question, and I don't appreciate the insinuation that being in the clerk's office is somehow inappropriate. If the board has a relevant question that it needs to know based on that set of facts, I'm happy to ask the clients to answer.
I'm having an issue with the relevance, as, you know, she has the right to go in, as many.
I'm not denying that. I was just asking because the whole thing is I just find it, I just find it interesting. She went in to find out, she's specifically testified, I guess you could say, that she specifically went in and asked about voter verification. And she's been living in this town as far as I know, long enough, and I believe her name has been married, or maiden name's been changed to a married name and all that. So I'm just trying to get a handle on why she would go in and ask that specific question. What triggered her to ask that specific question in regards to how the voter verification process is done?
And I don't believe I'm mischaracterizing the testimony that she wasn't, I don't know that she necessarily asked that specific question. I think she was providing an example to the board of why she was asking about verification, and then essentially used herself as an example, not necessarily that was the question posed to the clerk, but that was an example as to why she had gone in to ask questions about about signature verification. And expecting her to remember exactly the example is outside of the purview.
We're way off tangent, right?
I understand.
I was just going to say, Mr. Chair, she testified that she was there. She testified, she asked about the process. Any registered voter or any resident or any non-resident could walk into the clerk's office today and ask about certification. It's interaction with public officials. It's allowed by law.
And being a registrar, I've been in the office many times, and there are a lot of people that come in and ask very specific questions to that nature. We do have it, this is all on the record, so we do have it, so if you did need to go down the road in the future, you do have access.
Well, I mean,
to that.
Mr. Chair, here's the thing. We have the two petitioners here, and we had one that goes in the clerk's. I don't deny that, hey, somebody can go in there and ask about voter verification, but we have a petitioner here that is testifying today that she specifically asked about voter verification, using herself as an example between her married name and her maiden name, which I'm sure has been changed quite a while ago. And especially where there's so many concerns in regards to the signatories on the petition sheets in regards to their validity, I just find it interesting that one specific question that she testified to was asked and raises, in my opinion, raises some interest.
We understand your interest, and it's on the record right now. It's been recorded, and I believe we should need to move on for that purpose. Do you have any other questions?
That's it, Mr. Chair. Thank you.
Thank you.
Mr. Chair, can I say something very quickly for the record, if you wouldn't mind?
The record, sure.
Yeah, I just think it's very unfortunate that a conspiracy theory of this magnitude is being fabricated in an attempt to disenfranchise nearly 4,000 voters of the town of Marshfield. And I think that I couldn't come here today without having that said on the record. With all due respect to the objectors.
You're getting way beyond, because we're not here.
I understand. I just wanted to put it on the record.
Now you've just opened up the can of worms, because the people that you're accusing I'm gonna have to give them just a very short
Sure,
time
they
on
can
the
go right
record.
ahead. Yep.
But
They can go right ahead. They've been doing it all morning. They can go right ahead.
That's what they just questioned the signatures in the morning. Now
I think the line of questioning that just happened was clearly conspiratorial.
I'm not involved with that. So, I mean, we're way outside, and
Yes, we are.
We're gonna very limited, I really almost need to go to legal counsel. Again, this is an informal meeting, and we have very specific activities that we need to do as a board. And getting into all this other activities is way beyond the scope of this.
Yes, I believe
I was not expecting that statement being made from the petitioner at all on that. Again,
Understood.
your statement that you have right here states everything.
Yes.
And that's
Understood.
where, if it should go down to legal court and criminal or whatever courts and everything like that, that is what you're going to stand on. And I'm really unfortunate, I feel deceived a little bit by bringing that up. And now because I have a line up in the back there, and I am almost considered to say, we're not going any further on this. I think it's appropriate.
Yeah, Mr. Chair, the word conspiracy was used previously, the word fraud, the word fraudulently, and forged. In my experience, the conversation would end here. You've indicated that you're displeased by the statement. I don't think there's any value in having any responses to that.
I agree.
Thank you.
We'll probably end up getting it into signatures a little bit or something like that, but.
Mr. Chair, I just want to let you know I disagree with counsel's advice to you. The petitioner, Sean Costello, threw a cheap shot out there, and I think we should have the right to respond to it, especially calling it conspiracies when there are concerns around this whole petition drive and the fact that there were statements made by the petitioners that we're just looking for follow-up answers to.
Right. I agree, Eric, and everything like that, and I believe that you have other venues that you can make statements in rebuttal to the comment that was made. We also are going to have we have a whole signature section, which we're going to control to some extent the best we can, but still be open and understand the discussions that are going on. So, but right now, I think it's best that we don't go down that rabbit hole right now, because there will be a lot of other opportunities for us to discuss this.
I respect that. I respect that, but I want to say that I'm totally in disagreeing with it.
We have that on the.
That was a.
Yep.
Are there any final
We want
questions?
to keep this as an open and honest, and we don't want to get into he say, she say, that we don't want the degrade.
Just clearly shows who he is right now.
Please. Eric.
Scumbag.
Please.
I believe everyone's views are well documented in other forums. I don't think the board needs to hear anything further. If there are any other relevant questions for the petitioners,
Mr. Paceva's already.
I promise you this is relevant, Mr. Chairman, because what I just heard after Ms. Brate admitted to being in the clerk's office several times, there appeared to be an attempt by your counsel to dismiss it like that's normal. I know from many of my interactions at the clerk's office that people ask questions at the window.
They do.
And they don't go in and they're not present while an actual certification process is going on using her undue influence, and she's very influential in town. Thank you.
It's on the record now, Joe. Thank you. Okay.
Have you?
all right, if nothing further, I'm going to instruct the petitioners that they're free to leave.
Do they have anything else they'd like to say?
I don't know that.
No.
Wish not to?
I appreciate your time.
You're quite welcome. We appreciate your time coming in,
Thank you.
And maybe right now on the I don't know if legal counsel has told you, on the 29th, we're having another meeting. I don't know if your availability.
It's my understanding that with respect to the signature challenges, they won't be necessary. So they've come today and provided their testimony.
Okay, we'll discuss that.
Thank you.
Mr. Chair, so moving on, I think the other thing that would be helpful for the board before it moves to discussion of the legal issues is to address some of the factual background of what actually occurred with respect to the petition on the town side, on the clerk side. And I know that there were questions that also wanted to be asked of the clerk. But I think it's important that the clerk be requested to provide you with information about when the petitions were issued and what the circumstances were and things of that nature.
Okay. Sounds, we can dismiss them. Thank you.
Okay.
Thank you.
Thank you.
Could I ask? On the record, though, that I did not insinuate that Lara or Sean were part of the conspiracy. I just said they were dope. It wasn't.
It's on the
I
record.
didn't say that they were responsible.
It's true. Yep. No.
You just said it was.
Yeah, and there isn't. Here's the proof.
Clerk, or do
Okay.
you need a
Could I
break?
could I ask one quick question?
Certainly.
Attorney Ash, just from earlier, just based on what you're saying before, everything was done according to plan, but then there was, I just want you to acknowledge, the statement about the blank, or the blanks not having the seal and sign.
Yes.
That just, right,
Yeah.
but it was just saying, you said it all went in smoothly. I just wanted to see if you noted that and
what his thought was on that.
Yes,
Just
no, I
wanted to hear
appreciate
that
the
on
follow-up
record.
and the
Yeah.
and the question. At 950 CMR, section 55, I believe it is section 7 that quotes, "The registrar's failure to comply with any requirement," I'm sorry, it's section 11, "The registrar's failure to failure to comply with any requirement of CMR 5502 shall not invalidate their certification." So it is our position that the lack of a seal is a clerical matter that does not go to the integrity or the voters' wishes.
Okay.
Oh, so this is different than this.
Yeah, that's what I was looking for, just that you knew that that was,
0211.
was the case.
Thank
That's
you.
fine, thank you.
It's 7.
Yes. No, we comply. So this is, oh, okay, you gave me a package.
Yes, it's in there.
So this is like a cheat sheet. Because it's not.
Mr. Chair, the document that you're referencing is just kind of like a pamphlet put out by the Secretary of State's office with guidance or summary.
So this is section 55, subsection 11, "The registrar's failure to comply with any requirement of 950 CMR 5502, except for number 7, shall not invalidate the certification."
Yep.
Thank you.
Yeah, that's fine, thank you.
Mr. Chair, could you, I didn't hear that. What was the citation just made? What was the statement?
Mr. Chair, the attorney for the petitioners cited to 950 CMR 5502, Section 11, and then he mentioned 950 CMR 5502, Section 7.
Mr.
What point?
Go ahead, Joe. Go ahead.
To make what point? Oh, sorry. Oh, I'm sorry. What was the point being made in reference to the CMRs?
It was,
Yeah, no, I was just asking, because he said to reply about the seal and the date.
Okay. And I just want to remind again, Chapter 4, about the importance of a seal and the role of a seal and how the clerk is the keeper of the seal and is required by our charter to affix the seal.
And can I make one more comment on Mr. Chair, too, in rebuttal to what he said? It will be real quick.
Sure.
So, you know, you can put all this state law out and case law out. The fact is that it's clear from the Secretary of State's lawyer in the Elections Division that they only address timelines of this hearing. That's all state law addresses. That's for nomination papers or other things that go to court. Our charter is clear on what must be done, and the timeline of when they're issued is crucial to the chain of custody for the 21 days. That is crucial. None of this stuff has anything to do with it.
we have it all on record. Yep.
Thank you.
We understand, yeah. And it all will be reviewed as we debate and deliberate this. So I believe it's now time for the town clerk moment.
Yeehaw.
I'm in. Thank you.
Sorry if I use the restroom real quick.
Mr. Chair, do you want to take a 5-minute recess?
Sure, we can take 5 minutes.
I'll be right back.
Come right back here.
Yeah.
Well, I'll just
Sorry.
give you a chance to settle into the chair.
Thanks.
I'd like to call the meeting back to order, and we now have the town clerk. willing to provide us some information.
What do you want to know?
I don't, no, I don't believe, do you have an opening statement that you would like to provide?
I am the town clerk.
Okay? We'll have that on the record?
Mr. Chair, I think the questions that the board would need information about is just a general timeline of, you know, when the initial affidavit was filed, what the town clerk did with that, you know, what happened with the preparation of the petitions, whether she did that herself or someone else did, who they were given to, and, you know, when, we know there was 3 issuances, so when those occurred, and what were the circumstances, the certification, and then the additional petitions. I think that's the information you need for the record.
That's a lot of stuff.
I appreciate that.
Okay,
What
ready?
she said.
Thanks. Okay, so on Friday, April 3rd, Laura Brait provided me with an affidavit that satisfied the requirements for a recall. They had been certain, actually, we had actually certified the signatures. Lara dictated to me the petition for recall. I have dyslexia, so it's better for me if, when it comes to something where someone wants something in legalese, they dictate to me, and that way I don't change it for them. How's that? I have a tendency to edit, so this is exactly as she dictated it to me.
And the date of that was?
That was April 3rd.
April 3rd.
So she dictated it to me. The form that I used was from the internet. This is my second recall in 10 years. The first form that I used, I really didn't particularly care for. The problem with a petition for recall is that the petition is actually a petition by a citizen. It's not a petition, although it's for the town of Marshfield, it's actually a petition by a citizen, by a voter, actually. So it had been pointed out to me before, when I did it, that I had used the town seal. And I'm the town clerk, I'm the keeper of the seal. But it's actually a town seal, it's not the town clerk's seal. So, on consideration, although the charter says in specific, where is that? 8-1-2 says, blank shall be issued by the town clerk with his or her signature and official seal attached here thereto. Well, I am the town clerk. My official, as far as I'm concerned, seal is my name. And my name is affixed to the affidavit or petition, and I considered that to be my seal. I felt that putting the town seal on it would give it validity from the town, and I didn't want to do that. I didn't want to give it any more weight than a petition from a citizen of the town. So I made 200 copies because you have to control how many copies of a recall petition that you give to the petitioner, and stamped it in on the town clerk's stamp. And if you look at the copy that I gave you, it's on the side. And it was April 3rd at 12:39 p.m. And Ms. Brait left on my office with 200 copies.
Can we just pause there? Is that the petition that we had when we, is that what you left up here?
Yes.
Okay, so that's exhibit,
There are three petitions attached.
okay, okay,
Okay?
with different
Different dates and time.
Different dates, okay?
Okay. All right.
Mr. Chair, just to confirm that.
In the first line of the petition, you'll note that it says 200 petitions were issued to Lara Brait and Sean Costello because they were the two petitioners. The second batch of petitions, she asked for an additional 100 petitions. That one says, this is 100 additional petition forms, now totaling 300, because she asked for another 100 petitions, and that was on April 10th. Again, I made the changes to the document. I made the copies of the document. I gave them to Mrs. Brait. I retained a copy, and I stamped it in the town clerk's office on April 10th at 5:53. And then I got a little sloppy, and I made 50 more, and I gave them to Mrs. Brait, but then I kind of forgot to stamp them in and sign them, which was bad, very bad. Mrs. Brait had been bringing in, Mrs. Brait and I don't even know how many people kept bringing in copies of the petition. We go through a regular process. They bring in the petitions, we stamp them in the town clerk's office right upon receipt. I have 2 assistants in my office that have access to the voter registration information system for the state. We look up each signature individually. We verify that signature against their signature that is in the system, hopefully. If it's not in the system, we literally pull a hard card and we look at their signature. This is in excess of what is required by the state, but we are fully aware that in a recall, we are messing with somebody's life, and we take that really, really seriously. It's not something that we relish. And, you know, it's not something that we want people to think that we take lightly. And it's worth the extra effort. So the 3 of us looked at every single signature, and then we called our registrars in, and we had our registrars look at every single signature. If they had any questions, we would pull the hard copies that they had questions about. They also looked at the VRIS. Mrs. Brait came in regularly and wanted to know how many signatures we had collected, so that she could figure out where she stood with her 15%. On the 17th of April, they hit their 15% threshold. Now, 8-1-3 is the controlling language for what I do or what I am required to do once they hit the 15% threshold. It says that I am to advise the selectmen without delay. So when they hit the 15% threshold, regardless of the fact that they had not hit the 21-day allowed deadline for collecting signatures, it instructs me to tell the selectmen that they've hit the 15%. So I did. I gave them notice. And, you know, at that point, it's up to them to do their thing. We continued to collect signatures, we continued to verify them, we continued to go through the entire process until the 21 days were over. But basically, you know, that is basically where our function really stopped in this whole process. So, end of story. And now we're here.
Did you happen to take mine?
What's that?
Did you grab mine by chance?
No. that what you're looking for? That's that one there. Were you looking for this?
Mr. Chair, you looking for the laws?
Yeah, I know I have it in here. I got it in there somewhere. If he didn't take it, it's here. Thank you.
Okay. So we got to this point. If there is anything else, or?
Mr. Chair, I have some questions for the town clerk.
Mr. Chair, at this point, I think if the Board of Registrars individually has any questions for the clerk, now would be a good time to ask, and then after that, I would turn to the objectors in the same order in which you've been taking them.
Okay. Would you like to start, Dave? You have any questions?
Not off the top of my head, no. I mean, it's pretty straightforward, 'cause I think we got involved right in the middle of that. hearing. Go ahead.
Sounds good. All right. And Dave, online, do you have any
Is he
questions?
still muted?
He might be. You know, did somebody turn it down?
He muted himself on his phone.
Yeah, he muted. He can unmute himself. Here he comes. Now I can hear you.
Okay, thank you. All right. Not really a question. I just wanted to reiterate that one of the questions earlier were the registrar's job was to go over the signatures too. And I spent the whole afternoon in there doing just that and questioning and getting answers that I felt were adequate. So I understand what the clerk's job was, and I understood what our job was. And so I think at this point right now, we can go forward. I don't have any questions.
Okay, thanks. Just, you said that you had an extra 50 that you had to print, correct? Or is that 350?
They asked me to print another 50,
No,
and I did, but unfortunately, we can't actually print quantities in our office, in our lifetime. It takes forever. We only have personal copiers. So I have to go to the mailroom and actually print things, and it took me 3 tries to get it to print 50 copies on double-sided petitions, and by the time it got to the third one, I basically lost my patience and was not paying attention to what I was doing. I was very bad.
I was just curious, because there was no date stamp on there.
Exactly.
If it was very close to the time of the 10th or the 9th,
You know what? I'm not going to represent
estimate.
anything, because in all honesty, I can't tell. I honestly can't tell you.
Okay,
I mean, I'm not going to.
sounds good, definitely. And,
I would be making it up. I'm not going to say.
no, I just want to make sure, because I'm sure somebody's going to ask the question, and I just wanted to
Yep.
make sure that, it was done relatively early in the thing. Regardless, we have a collection of all the petitions that have
Yeah.
gone out, or.
No, it's totally my fault. I just,
Yep. And then you made a reference in the 813 where you had to notify the selectmen without delay. And I thought I heard you say 15 days? Or there was a,
I notified them because I notified them the minute I knew that they had hit the 15%.
okay, 15%.
Because 15% is the triggering amount that you have to get in
Right.
order to, 15% of the voters is what you needed to have in order to trigger a recall. So once they hit the 15%, the way this is, it's oddly written, for lack of how's that? Wasn't that polite? It's very oddly written, but it literally says that she shall submit the same with the certificate to the selectmen without delay. So without delay means that I need to submit regardless of what the time is. So I submitted it the minute they hit the 15%. And I was doing a tally every single day because Mrs. Brait was asking me pretty much every single day where we stood on numbers. You know, and it was much easier just to have the number there than to say, hold on, Mrs. Brait, I will run.
And my concern, I'm sure there's going to be questions that are going to be posed, everything like that. And then this is where I'm going to turn to legal counsel on this, because the word certificate or certify that, and that occurred on the 21st, and it did not?
It occurred before the 21st.
Oh, okay. That's,
Mr. Chair, if I may, I think there's a few other pieces of information that would be useful.
okay.
One of a number of the objections had to do with the timing and the lack of a date stamp on when they were issued. Would it be useful for the clerk to explain when those petitions were issued and if there was any possibility that they could have been issued before April 3rd?
If there's relevance there, sure. but I
Yeah,
mean,
because
I have-
some of the objections that have been made relate to, the fact that there wasn't a time and date stamp, which I think goes to the question of when were they released for signatures? And so, that seems like a question that'd be useful to have in the record in terms of facts. Were these petitions, is there a chance that any of these petitions could have been issued prior to April 3rd?
Oh, okay. Because I'm looking at a document here that's an affidavit, and I'm assuming this is for the 100 registered voters that you have to have that came in at 11:45 on April 3rd that was received. So I'm assuming that there was nothing, correct me if I'm
Yes.
making the correct
I think-
assumption, that you used this document that's stamped in on April 3rd to start the initial
I think what Ms. Goldberg is saying is, and I believe what I had said was that this document, the petition for recall, was actually created on the 3rd. I created it on the 3rd by virtue of Ms. Brait actually dictating it to me, which is, I think, what she wanted on the record. I created it on that day. It did not exist until that day.
Right.
Mr. Chair, the other thing that I know there's something in the objections about maybe not having a timestamp on when some of the petitions were received. And I guess the question I would have, the board consider asking is whether any of the petitions that have been certified were received after April 24th at 5 p.m.
Okay, I mean, sure, I believe the.
That's a question.
That's a question, okay.
No.
No.
Okay, and then, and I know the board has looked at these petitions. Is it the case, Mr. Chair, that certain signatures were rejected on these petitions because they didn't meet the standards in the CMRs?
Correct. The town clerk, I understand that the town clerk has a procedure to go through how to verify the signatures in accordance with the CMR, the 950 CMR 55. And then the registrars also participate in that activities, and they're all well documented and everything of that nature. So the question is that you do follow your normal procedures.
We actually exceed the requirements under CMR 950.
Yeah. Okay.
Yes.
So, again, I know it seems,
You did nullify some of them, correct?
We did.
Yeah.
okay. There's another question that I wanted to ask. Just give me 1 second, let me check my notes. I guess the last kind of area that I think we should at least focus on before we turn over for questioning is, what does the town clerk see as the purpose of the seal? What does the town clerk see as the purpose of the signature? What does the town clerk see as the purpose of the provision that says that the petition should have the date of issuance? Just to get a feel for kind of what the official action on these petitions was and why.
Mr. Chairman, is Lauren part of the Board of Registers of the town of Marshfield?
She's legal counsel for.
Come on, she's going too far here.
Well,
Mr. Chair.
I think it's more for the record than anything else. And Noreen had already sort of, in her opening statement, explained her signature and the stamp and everything of that nature. So,
Mr. Chair, my concern would be that the board wouldn't have enough information to make a finding that the petitions were or were not, valid, and so I just want to make sure that the facts that you need to make a decision are available to you. And, I think it's also really important to recognize, from my perspective as a legal matter, this board is sitting as kind of judge and jury, not to come out on one side or the other, but for the purpose of being able to make a decision that's fair and consistent and based on fact and not supposition. So that is why I, wanted to bring those issues to your attention. And
Well, as an objector, I am completely satisfied with the ability of the Board of Registers to make this decision
they can.
so, yeah.
on their own.
Yeah, I appreciate that, so. The question, one of the questions that I had, and again, this is where I was turning to legal counsel, is on the 813, where we talk about the certificate, and then you issued the certificate without delay to the select board and everything like that. Again, understanding and hearing some other the conversations that are going on, I'd like to know from a legal point of view, when does the drop date, does that certificate have any legal, the date that that certificate was sent to the select board, does that have any effect on the overall income of petitions that might have come afterwards?
No.
I just want to clarify from my point of view.
From my point of view, no.
Okay.
From my point of view, it's a requirement to me under this 8.1.3 that it's incumbent upon me for some reason to report to them immediately that they've hit the 15%. I don't know if it's because whomever wrote this thinks that, they need the extra time to plan, or I honestly don't know. I think a lot of this is weird.
Okay. I just.
But I have no idea.
I just want
But
to
the thing is it says without delay. I did it without delay.
Okay.
And I called Mr. Kelly over the weekend because it is my practice to try to give advance warning when something like this when something bad is happening. And I was unable to speak to him personally, and so I had to deliver it.
I just want to make sure from my mind, because we will be talking about it and discussing it and everything.
Yeah.
The certificate to me could be just something that's more of a formal notification to them. It does not have any effect on the outcome or something of that nature. Is that?
Yeah, it's just,
I just want to make sure.
I don't, I think a lot of it is, I don't understand where they came up with the language. It was way before my time, and it seems a little loose to me, but I just have to do what,
We have to
And it's
work
only
with
my
it.
second one, and hopefully my last.
Definitely. Okay. So I don't
Please,
have any.
dear God, my
I don't
last.
have any other questions right now.
The seal.
The
You want to
seal.
know my thing on the seal?
Sure, the seal.
Because, that seemed to be one of the things. So on the seal, I do believe that there is a difference between the town seal and having a clerk's seal. I've never had a clerk's seal. And it does, I'm very, very careful about how I use the town seal. I give everybody a really hard time about using the town seal because it does give the impression that the town is giving its permission or, it gives so much weight to whatever it's on, and it gives you the impression that the town is backing whatever it is. And I am, I constantly am sending nasty grams and letters to people because they put the town seal on the Marshfield Forum. Things that have Marshfield on them, shirts, sneakers. And you can't do that. I mean, it makes it doesn't, it gives the impression that it's not as important as the group of people that founded this town in 1640 and all of the people that have come behind it that have made this place great. And I feel like that is what I am protecting when I use the town seal. And that's not the town clerk. That's everybody.
I appreciate that. Thank you. Seeing no others from the Registrars Board, I'll ask Steve if he has any questions. Town clerk.
So first off, delay does not exactly mean the second that you hit 15%, because you hit 15% on April 17th, right? And you sent the letter out on April 21st.
Whenever I hit it on the Friday and I delivered it on Monday.
Right. But you're not calculating them every single signature one at a time. You could have hit 15%.
I have to hit 15%
Day
in
before.
every single precinct.
I get it. So anyway, this is, well, first off, let's go back to, I thought that it was just a mistake that you made by not putting the town seal on, but now you're telling us you did it on purpose.
I did.
So this is, Eric has all of the recalls from the first attempt to
Correct.
recall him?
Mm-hmm. Yep.
Hundreds and hundreds of them.
Yep,
There's the town seal on every single one of them.
right?
Why'd you decide you could put it on that one and not on this one?
Because it was my first one, I hadn't really thought about it, and then I realized that I shouldn't have done it.
So you think that you have the right as the town clerk to make decisions of changing town charter?
No, I have the right to put the seal on what I determine is correct, because
No,
I
it's-
am the keeper of the seal.
It's
That's what I think.
absolute direction by the town charter how to do the recall. It's absolute.
Steve, we can't really get into this debate right here because it's a legal issue and it's beyond really the purview. You have a more of a
Well, we're saying that because the lack of the town seal, that none of these recall petitions are any good.
I agree, and that is your position.
And the town clerk's saying that you decide to put it on one and not the other. I mean,
That's
come
her
on.
choice to do that, and she gave a reason why, and we should accept, and it's on the record why she did that. And I don't know if there's any further materials gained by asking, it's now recognized, have you turned it into as a...
Okay, no, I have another question then. How many petition sheets do you think that you certified?
Me?
Yes, you.
A lot, because Lauren was on vacation, so a lot.
So, like, for instance, do you happen to remember any? Like, did you do the Lara Brait petition sheet? Did you do the Sean?
I have no idea.
Costello one?
I have no idea, Steve.
So, first off, let's establish one thing. The law is that even if you know it's a forgery, you can still certify it. That's the law, unfortunately. It's our job as objectors to step in and say, these are forgeries. So it's not like you went through all these signatures and said, oh, these are all legitimate signatures, because you don't have to say that. All you have to know is that that signature matches that address and that voter is at that address. Even though you know it's a forgery, you still can certify it. My job as an objector is to say, no, these are wrong, and that's what we've done here. Because, let me tell you, there are hundreds of forgeries in this
Okay, do you have a specific question that the clerk, I understand your position, but
Okay.
this is not a debate hall, unfortunately, and we're just trying to provide an opportunity.
Okay, so should we put the Sean Costello sheet into the record now? Because we have a copy of it, of the one that he signed and somebody else signed, whoever it is.
Please feel free.
Sure. Joe, do we have that? The Sean Costello sheet?
I have to dig it up.
We'll get it up. We'll get it up there. But anyway,
It is.
as long as we know we're gonna put it into the record.
It'd be gone to the record.
Yeah, because I have it at home. You guys, and you have the Lara Braid copy. And actually, I have another set of copies. Did a number.
Right here. But I want the copy back, though. I need a copy of that.
So it's our contention that one of the signatures is a forgery.
Okay, but, all right.
It's, I think it's number 327, page 327. Sorry.
You want to label it? This, oh yeah, this one was not labeled, that's why we did.
Is that, is that
That's
number
the law.
327?
That's the library one, but
Oh,
it's
yeah.
not, no, it's not
Okay.
labeled. They're different forms.
Mr. Chair?
Sure.
If I may, can we just hold on to this until we make a photocopy? We'll label it with an exhibit number, and then we'll make photocopies of all of these, and everyone can have their real documents back.
Originals back.
Yeah.
Correct.
Okay, thank you.
And we know whose original goes where?
Yeah.
Okay,
Yeah.
all right, I'm all done.
This would be petition, sorry, this would be Exhibit G, and I believe this came from Mr. Pasevich, so we'll make sure that he gets
Would you like to
that.
have one of these too? The ones, the first three
If
holes
you
that the
wish
town-
to-
The town stamp is on, those also.
Okay, you wish to enter that
Yeah, and
as an
there's a whole
exhibit?
pile of them, every single one of them has that town stamp on it.
Okay.
Exhibit H.
This goes to the
I got it.
All right, well, thank you, I guess I'm done.
Thank you.
Appreciate it.
And then we would ask if Pam had any questions. We're trying to do it in the same order that we've done
Oh,
before.
that's fine. Go ahead, Pam. No, I have one more time.
All right, I have a few questions. Can I just know more, when the registrar's stamp is used, like, there were 200-plus pages, is it the same, is the registrar putting the stamp on, any registrar, anyone, or is it the clerk who puts the stamp on?
The clerk.
The clerk, okay. And so, and then, has the board ever officially, that you know of, given permission for the clerk to use the stamp? In a vote, or any other letter, or anything like that?
Specifically to your question, to my knowledge, because I'm relatively new, and Dave is very new to it, and I'm assuming that it is a standing procedure that they have established in there, and we've worked with the clerk on many others. Dave O'Reilly probably is the longest-serving registrar that would have that could say that there has been that discussion, but I believe it's assumed that, as the regulation says, that we understand that there are duties that can be applied to the town
Yeah.
clerk that are
They
part
do,
of the registrar.
I don't have the regulation in front of me, but it states that you are supposed to, I guess, formally give permission either through a vote or something else. So I don't know if the clerk knows, since she's been here for a while, too.
Mr. Chair, if I may, the regulations, and actually, I'll just grab it, but what it basically says is that the duties of the clerk, the duties of the registrars can be delegated by vote or otherwise. It sounds, I don't want to put words in your mouth, but it sounds to me like you're saying it's past practice, and that's how it's handled.
That's-
Okay. Narice had started to say something earlier, quite a while ago, where you were talking about her letter, and she said something about before the 21st. And then the conversation changed quickly. Was there something, I didn't understand what was going on. Do you, Narice, remember anything about, you were talking about something being done before the 21st?
21 days. He said the 21st, I think he meant the 21 days.
I think I was asking the date of the certificate when that was relayed to the select board, and I thought I heard the 21st.
April 21st.
April
I'm
21st.
sorry, I thought he meant the expiration of the 21 days.
I
So
just-
It was April 21st was the date, the
Okay.
certificate.
That was reached on the 17th.
Yeah, that's what, somewhere, the town clerk said something like sooner and before that, and then the conversation changed, but if it's lost, it's lost. I just want to make note of one strange thing. I realize that the clerk is basically testifying that the time frame, even though there's no date and all that the time frame is done within what the charter says. In the batch of 200, there's actually one paper, and actually I don't have the number right now, and I don't remember it, but there's one paper where the town's clerk's signature is different from the rest of the papers, because her signature is a photocopy on all of them. It looks like possibly an error was made, and then there was a gray box with Mr. Kelly's name in it, and maybe there was a correction there, but you actually have a batch that does not fully agree with itself by that one page. And then,
Is that a question directed to the?
well, it's just, I just want to tell the board that, when you're talking about this chain of, whether it's a chain of custody or things are done in a timeline or whatever, there's a page in the 200 page that doesn't match the rest of them. So whether there's any notation as to where that page came from, I don't know. And then, I just want to note on the 21st, I want to know if the clerk could tell us a little bit of how my understanding is that the whole package, a letter and the package of all the sheets, probably a photocopy, I guess, went to the selectman's office, and that Steve Darcy took them home. I'm just wondering if is that what the town clerk knows of? Is that what happened? Did she deliver a package to the selectman's office on the 21st?
I brought it up to the selectman's office, but I didn't know he took it home.
Yeah, I believe he admitted to taking it home, I think, to Mr. Lynch, I think.
Which I find.
And that's it for questions. I don't know if I should be making a comment, but the conversation or testimony that she gave about the seal having all that weight is exactly why I say it should be on the document, is because of the weight. Those documents should be sealed. They really technically should be sealed, I think, with the raised embossed seal that people can see. That gives it weight. Like I showed you that little attest true copy stamp, even though it's a small thing and it's on the bottom, it shows you that it's something formal and it's been given certification by the government. And this recall process, even though I understand her thought of where she's coming from, that, we don't want to make this an official government document, but technically it is. That's what the charter spells out.
Okay.
The government is giving it authority.
We have that on record, yes.
Joe Pasevich again, objector. Yeah, just a quick follow-up on that point. The town clerk makes great emphasis about how serious this is, how someone's life is being affected, how it's deadly serious, and it is an act being carried out under the law. So all the more reason to let people know this is something serious. This is not an opinion poll, okay? And that's exactly why it should be stamped and have a seal on it. Now, I want to ask the registrars, you're all sworn, right? To uphold the Constitution, you take an oath of office?
Yeah. Well, we're sworn in as registrars, correct?
Right, to uphold the laws of the Commonwealth.
Mr. Chair, the Board of Registrars serves as a judge and jury here. They're not required to answer any questions, and whether to answer any questions is completely within your purview. You can decide yes or no. Obviously, the registrars have a statutory role, and that speaks for itself. So I just want to preface that before Mr. Pasevich goes forward.
I'm trying to finish my point before I was interrupted, excuse me. But you are sworn, you do have a role in certifying the signatures. That's unavoidable, regardless of your role in the hearing. So it is your role not to just accept the clerk's arbitrary decision on whether or not to use a stamp because she has empathy or emotional feeling for somebody, that's going to be the determinant when a seal gets used and when it's not getting used. It's the registrar's job to make sure, and oversight of all the citizens, including of objectors, to make sure that the law is being obeyed. Now, going back to some of the statements of the clerk, she said that she received at 11:45 on Friday a petition from Lara Brait, a petition containing 100 signatures. And the clerk's office typically closes at 12 o'clock on Fridays. How was it possible was special consideration, or did she give special consideration and treatment to Lara Brait to then certify 100 signatures in basically 15 minutes and issue 200 petitions in that short a time? Is that what happened? Am I understanding that correctly, Mr. Chairman?
Is that a question that you're asking
Yes.
the town clerk?
Yes.
How she
Well,
processed?
through you, because you're, yeah. So is that what happened? Did I hear that right?
I'd have to default to
Okay.
the town clerk as to the procedure that she handled. And I'm assuming she handled it in a good faith way and did the process it. And Norris has worked many hours after hours, so I'm assuming that she did what she needed to do at the time, so.
So the understanding then is that,
Actually, they sat on it. They sat on it for days thinking about it.
Oh,
They actually sat on it for a couple of days thinking about it, whether they actually wanted to go forward.
Mr. Chairman, I object to that because she's speaking for someone else that's not here. That's a
No,
question for
no,
Lara
no.
Brait.
I'm not.
For you to say that
I'm
she
not
sat
actually-
on it
I'm
is not your place.
I'm not actually. Yes, I am. I gave them the form.
Okay, that's my next question, Mr. Chairman. When was this petition for 100 signatures given to Lara Brait and Sean Costello?
You'd have to look at the back of the,
It was issued to them on what date?
That's the affidavit you're talking about, right, John?
Right, the initial affidavit.
March 31st, is that possible?
Yep.
We, the undersigned voters, yeah. Yep. March 31st, by the document I have.
Before the selectmen's meeting that caused all this kerfluffle. Okay. So now that petition was dated on it, had an issuance date on it. But the petitions to recall don't have an issuance date? There's a little inconsistency there.
Do you have a specific question? Because
I'm making a comment, I'm just trying to make sure I understand what I'm hearing, because the clerk has made statements which are now subject to scrutiny. The next thing I want to say is that so it was issued, we're saying it was issued March 31st. It was returned at 11:45 on Friday, April 3rd. Immediately, 200 recall petitions somehow find their way into the hands of Lara Brait, because we know they had to have worked that weekend, and they collected a lot of signatures, because at 9 o'clock in the morning on the following Monday, April 6th, a pile of petitions shows up. So the clerk gave deferential and special treatment
you have a
to...
specific question, Joe, though. I mean,
I'm making a statement. The clerk
You're making
gave
a-
special treatment for
This is
these
not-
people. That's what I'm understanding. I want to make sure everybody understands what happened.
specific question as to what time or what date they might have provided that.
So when were the 200 petitions issued? What time and what date?
Ask me what time the town clerk's office closes on Friday.
12 o'clock.
What time does the town clerk's office close on Fridays?
12:30 on Friday.
12:30 on Friday.
Thank you.
So were 100 petition signatures on an affidavit certified in 45 minutes, followed by 200 issuance of 200 petition sheets. Was that all done in 45 minutes? That's a question.
That's a question.
No.
No. The answer is no.
It was not. Okay, so it was done outside of working hours. The next question I have is with regards to 8.12 of the charter. The recall petition is referred to as the petition. The town clerk, within 24 hours of receipt, submit the petition to the registrars of voters. It's always the petition. The reference to the petition being something that is like a moving thing, it's a triggering device. That's not what this law says. A petition is the petition. It's not some portion of a petition. It is the petition.
I understand you're trying to develop your substantiation for your question. Can you please narrow it down and ask the specific question? Because we
Right.
all are very familiar with activities.
Right. Well, you, Mr. Sterling, Mr. Chairman, you also have worked in the clerk's office, correct?
Very correct.
You have. So you have been an
So you have that
employee
question?
of the clerk's office. You have been an employee of the clerk's office.
Technically not an employee, I'm a volunteer as a registrar, but do you have a question?
Okay. But you receive some remuneration.
Doesn't matter, sir.
Well, it does. Okay.
Actually,
My next question is, did the clerk work on the weekends of the 11th and 12th, Saturday, Sunday, and the weekend of 18th and 19th, Saturday, Sunday? Did they work on those petitions, on those recall petitions verification process? That's a question.
The question if people worked on those days?
Yes, on the weekends, Saturday, Sunday, the 11th and 12th, and the 18th and 19th.
I did.
The clerk answered it in the.
She did?
Yes.
Okay, she did work on weekends on that?
Yeah.
Okay. Obvious a sense of urgency, I can see, for something that's so life-threatening and life-changing for somebody.
Again, Joe, I'm going to have to start saying that you either stay with your questions to keep it moving. I know you have the podium and you want to add a lot to it, but those were times, you have a moment to ask a clerk a question.
I am asking questions, but sometimes you have to understand the context. Again, and I also just want to say that, again, you have taken the oath. It's up to you to interpret the law, and the
Chair.
clerk seal, the clerk did
Mr.
just
Chair,
state
if I
that
may.
that a seal was not used.
Joe, that's beyond the authority or the discussion that we're having right now.
I have a question. Does the clerk think that the use of the seal maybe caused the first petition to fail, the first recall effort to fail?
That's a subjective question. I don't know how she could come to a decision on that, but
Well, it's just a question. I mean, she
like-
says it, she said that the seal, the presence of the seal makes a difference in how people look at things like this. So I'm asking, she must feel, did the first recall fail because the seal was on there? That's a question.
do you wish to provide
I
an
have
answer?
no idea.
She has no feelings or no idea at all. So,
That's all. Thank you, Mr.
Thank you.
Chairman.
yes, Eric.
Thank you, Mr. Chair. Nerese mentioned that she got sloppy. To my understanding, if I understood her correctly, she did not sign or date 50 petitions. Would I be understanding that correctly?
Yes,
What happened with those 50 petitions?
I gave them out, but I didn't sign them.
So you gave them out to be signed, but signatures by the petitioners?
I did.
Okay. So they are part of the record for the petitions that you certified.
I did.
I would like to ask if, for the registers, and I know the attorney said it's up to you to ask if you want to answer these questions, but I think it was mentioned that, I think Nerese mentioned that the registers did check some signatures. Do you know exactly what signatures that you checked?
I'll speak for myself. Go ahead.
Yeah, I can honestly say I would not be able to tell you any specific signature I checked, but there were many, many.
There were many.
Yeah.
Can you put a rough number on it?
I probably looked at, I don't know, 300?
300? And what was the reason for you to look into those particular signatures?
Sure, they were completely illegible on the paper. It could just be if the whole sheet was full and I didn't see one that piqued my interest, I just arbitrarily pick a group. It was just to get a random sample, but things that stuck out, like a mess, would definitely trigger me to look into it.
So what are you saying, that there were signatures on there that grabbed your attention, that you felt you had to verify that may not have been the actual signature of the petition, the signer of the petition?
Well, yeah, I may have looked into it, and then if it matched something that was in the database, then I'd pass it along. If I had more questions, I'd ask for backup information.
So is it a may, or you did have concerns in regards to some of the signatures that you looked into?
Well, if it didn't match.
Mr. Chair,
Please.
I think the CMRs and the...
Mr. Chair, the attorney
Mr. Chair,
spoke that it was up to you.
Mr.
to
Chair,
The board,
if
if
I
you
may.
wanted to ask the questions. He's already stated that, and
Mr. Chair,
and the board is already
Wait, no.
volunteering to answer those questions. So I would like not to be interrupted, as it's already been stated, it was up to you. and-
Mr. Chairman,
Let me just, her position.
the petitions have a reason why the signature was rejected. Those are the reasons, and the registrar's job is to look, whether it's delegated to the clerk or not, is to look at the signature and the address, look up the address, compare to see if someone's there, if the signature is illegible, or if there's no one at that address, or any of the other reasons not to certify. The code is put there. So I don't think there's real value in the registrars testifying to the fact that they do their job. That is the job. And at this point, given that you looked at 300 or more signatures, any particular recollection is unlikely. Just the general process seems to be more likely. So while the board can continue to answer questions if it wants to, in my opinion, the documents speak for themselves, the process was followed, the reason for rejection is there.
And I was going to agree with, I was going to mention it to Dave. Again, Dave is relatively new, I mean, within months, maybe? So he does that. The bottom line is, we follow the CMR, we follow the outline, that criteria to look at them. We look through the signatures, and we identify those that we might be suspect to. We're performing our duties as best we can in a very open, above-board activities. And again, the state has that very specific requirement that we're not here for fraud investigations. We are not signature specialists, but we have done the job the best of our ability, given the information that we had to work with. So,
I don't think I'm really questioning on the potential of fraud, which it looks like. I'm just saying in regards to, there was a statement made in regards to the registers checking the signatures by Nerese, if I'm correct. So the whole thing is that, like I mentioned, obviously you don't have to answer, but a board member chose to, so I asked the question. So there's
Right.
nothing wrong with that, in my opinion. And the whole thing is that
I
it's
agree
not
with your
based on.
position, Eric, that we did what we had to do in accordance with the information we had. So we performed our duties as we were required to.
Yeah, I know. The whole thing is that council says, you can't use recollection. The whole thing is that recollection is a big part of it, for anything.
Mr. Chair?
No, when you do those, you go through them, and you look at the next one, and you don't recall those things. You're very specific in what we're looking for. So we don't have, and I've been doing it for many years now, and you do not recall.
Mr. Chair,
Specific names.
the other issue, and I'm sorry to interrupt, the board is going to be asked to make decisions on signatures. So you shouldn't be testifying to whether you think the signatures that were already certified are certified. That's really the point that I was making. Certainly, you can and you chose to answer questions about the process, but ultimately, the decision on any particular signature is something you're going to have to rule on.
Correct.
And the difference between ruling on that here and ruling on it at the initial signature certification phase is that here you can look behind, you have the ability to look at signatures to think if you thought, to decide if you think they were signed by the same person, and to reject a certified signature on that basis. The initial time around, even if you fully believed that they were forged or fraudulent, you would still be required by law to certify. So again, I think the opportunity to look at each of these signatures and have the conversation that essentially Mr. Kelly is suggesting, that there were signatures were there signatures that jumped out, et cetera. By law, you couldn't have done anything about that, but now you can. So if individual signatures are brought to your attention, you can discuss, you can deliberate, and you can make a ruling on that.
Is council done?
The council's done, and I agree 100% with what she's stating, because we do have the chance for you to bring your signatures that you question in front of that discussion.
I understand that. The whole thing is that it was brought up. You allowed me to ask, and I did. So the only thing is, I'm going to ask you, and I guess Mr. Riley, do you wish to make comment on it right now?
Not at this time. As chair, I wish not to get into the signature debate, but I'll leave the other two Daves for their position, because we
I
have,
agree. I think we are tabling the signature debate for the next meeting, and I think we can go over it with a fine-tooth comb then.
Yeah, I think we gave you enough, and, yeah, we definitely did do our job.
right.
Where the clerk's office contains sensitive documents, is there any town policy on who can enter the clerk's office?
We keep our sensitive documents in the safe. So
That's not
they
answering
don't
my
have
question.
they don't have access to the sensitive documents.
That's not the question I asked. Where the clerk's office contains sensitive documents, is there a town policy on who can enter the clerk's office?
The only people who can enter the office are people who are invited into the office. The office door is locked.
So are you saying there's no town policy on it?
No, there isn't.
Okay. Or I should say, town policy or any policy on it. The town clerk made testimony to having dyslexia. Would I be correct about that statement?
She was an
Yes.
affirmative, yes.
Can the town clerk explain what dyslexia is?
Yes, it's a,
The relevance
this
of, the relevance of the question.
She says she has sounds like a medical condition.
it's a learning
Right, but
disability.
what effect does it have? I mean, I think we're
I'll
going
get to that.
beyond
I'll get to that. when-
controlling the signatures and the
I'll get
petition.
to that question, if she can inform the public of what dyslexia is.
Mr. Chair,
Sure.
you have the ability to decide whether you think this is relevant and ask the objector to move on or to accept this line of questioning. The issue before you is whether this is relevant and whether a person who has come here to provide testimony and information should be grilled about a disability.
Is there relevance?
Let's put it this way, Mr. Chairman, I'm not grilling her, I'm just asking her a basic,
Again,
the petitioner, a basic question of,
We're still.
she can explain what dyslexia is, just for the record, as we're all here. But I also, and I'll add on to it, if you care to know, and does she believe it impacts her ability to do the town clerk's job effectively? She's already mentioned that she's messed up on 50 petitions, so, and she's mentioned that she has, I guess, some dyslexia, so.
It's almost a personal attack on female.
No, don't spin
But
it that
again,
way.
I
Because all things that it was a personal attack, that I would be bringing up without the town clerk bringing it up. She made mention of it. It may have relevancy here.
It may have, but again, we're looking at the recall petition and the signature. She has stated how it's been processed.
Did she not provide testimony saying that she has dyslexia?
Yeah, but it's irrelevant.
Why, all right, please give me your opinion why it's irrelevant.
Because she has time to review it and process it, and there's been many other people involved with the whole process. This is not a debate.
That's the problem, is that it is in a way a debate, because that's why we're all here, because we think the process is deeply flawed right now.
Okay, and what we'll do is we'll put that on record, that you feel that this is deeply flawed, so that if we need to take this down the road to any other venue, you can then pull this up and say, I had my moment right there, and let the next venue handle it. I believe this line of questioning might be out of order just a little bit, where it's going. So, I mean, we're very specific questions on the relationship of the recall petition and how it was processed in the town clerk's office. And I'm assuming, she is very capable of handling her disability and making sure that she does it in a proper way. So, we're not here to challenge that.
I just wanted to make a statement, Mr. Chair, that is your opinion.
Very much so.
Okay?
Mhm.
We don't know because we didn't get an answer to it.
That's true. But again, it's not, we're here for a debate. Do you have another question, please?
I do, sir. It was mentioned that Nerese, and I know sometimes these things are out of hand, or are not in her control, but she protects the town seal. There have been quite a few instances in the past where.
You're a scumbag.
Thank you, pal. You're right up there with Sean, too. The town seal's been used for initiatives in the past with the town in regards to groups trying to push an agenda item. And they put the town seal on, and then people complain, and then they got to take it down and all that. The unfortunate thing is that if you look at the state law in regards to the use of improper use of town seal, I think it's limited to $50 in fines and all that.
So your question is?
Hold on.
Because she's already testified the reasoning on her seal.
No, I get that. I get that. So I just want to make the statement, not as a question, that.
This is a time for questions and not statements at this time, so.
It's, well, the whole thing is that with the importance, which lays importance on the seal, which is correct, that seal has a lot of weight. Between people using it to maybe move agenda items and all that and everything, that may not be officially backed by the town per se itself, but also that seal is
But
it's
again,
important on documents that require it.
I agree 100%, but the thing was, we already had that testimony this morning about the petition itself and the seal and everything else of that nature. It sounds like you want to repeat some of that stuff. Do you have a question that you want to pose to the town clerk?
Yeah, in regards to, I guess it's like this, with the amount of time that's been put in, it seems like with this petition, I know Nerese said she was working weekends. Was the staff working weekends or overtime in regards to fulfilling the obligations of the petition itself?
No.
I didn't hear.
She said no.
No?
She answered
Okay.
in the affirmative. No.
That's it, Mr. Chair. I appreciate it. Thank you.
Okay. I appreciate that, too. Thank you. Is there any other questions of the town clerk? Nope. All right. So, just, you may step down.
Oh, well, thank you.
You're quite welcome. Yes. Mhm. I do have one statement for clarification purposes and more of a request, and I don't see Joe, but his papers are here and everything like that. Earlier, we talked about, you asked a question from the petitioners of who they gave out the petitions to and everything like that, the chain of control and everything like that. They answered the question voluntarily on that, and we're going to provide the names. We just ask that you be very, very cautious and open when I'm assuming that you might reach out to contact some of these people. No.
For the subpoena, that's it.
That's it? Okay. So, but again, I don't understand, just be,
In a formal setting.
okay.
Mr. Chair, I just,
Any options to do like closing statements next week?
Possibly, yes.
Mr. Chair, I just wanted to point out, in terms of the purpose for hearing from people who handed out petitions or sought petitions, that information would be relevant only to the extent it's relevant to a particular signature challenge. The time to make the global objections and to raise kind of the general objections to the validity and legality of the petition was today. And so, I think it'll be a decision for the board. I mean, it can make it now, it can make it on, next Friday, as to whether that testimony is relevant at all to the decisions that you are going to have to make with regard to the individual signatures. And, I think that's something that the board can think about either now or over the next few days. Obviously, the board can't deliberate between now and the next hearing, but the legal issues that were raised and the factual issues that were raised, part of the thinking in terms of how next week goes is deciding what is and is not relevant. So I just want to make sure that the board is aware of it.
So I can explain how I can make that applicable to that, and that would be when they give me the list of people that collected signatures, especially if that person is the first one on the list, and I think that page is forgeries, I want to be able to ask that person if they signed those names. So that's part of the signature process.
And then we would do individual signatures.
Yes.
We're not going to do a global activity. I just wanted to be very cautious. We did not want to cause any heartburn out there. We cause people to have issues and scare away.
So if you don't want to do that, Mr. Chair, then rule on the law right now and end this so we don't have to drag a bunch of people from this town in fighting against each other and dividing this town any further. It doesn't matter. They got what they want. They're going to have their election on July 25th. It'd be easier just to end this right now on the law that the affidavits and the petitions weren't sent out correctly, and then we don't have to deal with that. It would be doing everybody a favor. Let's just end it. Rule right now. Let's end this whole thing. And then I don't have to subpoena my neighbors in and put them under oath and ask them if they forged something. And put them under the penalties of perjuring themselves or saying they had committed a crime by forging something or taking the Fifth Amendment. It will do everyone a favor here. You'll be well within your legal right to end this right now.
I understand that, but it's just...
Thank you.
You're quite welcome.
Mr. Chair, certainly the board has the ability to decide issues of law if it chooses to right now. I would just note the board got a lot of information today, and although there have been filings before, probably now they're more accessible because you have the additional information that was provided today. The other thing that we have to consider is that if the board were to make a decision that these petitions shouldn't be, that these petitions don't meet the purposes of the law, if a court were to disagree with that, we would have only done one half of the process. And ultimately, it is not the board's responsibility or fault. If persons are subpoenaed, that is the responsibility and action of the objectors only. I think no one needs to, subpoena anyone. There's no requirement that that be done. The board can make a decision as to legality and validity of signatures on signature challenges simply by looking at the signatures. So, I don't know if the board even wants to take testimony on those issues, but ultimately the board doesn't need testimony to make decisions on signature validity in a situation like this one.
So,
Mr. Chair, I just want to let you know that I do have, I want to present my side as well when there's an opportunity before you close out.
So that, Mr. Chair, that sounds like people want to do closing arguments.
No.
no.
I have more information to add. Remember, I asked, not at this time, but consider it, I wanted to.
Exhibits? You wanted to add exhibits?
Yes, I guess you could look at it that way.
Okay. I mean, I will allow you to add the exhibit and provide it to council. So,
Do I get to speak on it?
pardon me?
Do I get to speak on it?
I'm assuming it's related to signatures in the petition, so, I mean, it's nothing new, yes, except it's, what?
No, because I have, Steve already gave you, I think, a copy of the sheet of the last
Recall election?
last recall election, right? I don't think you need.
We don't need
300
200 copies
pages
of the
it,
same
right?
thing. No, the point's been made.
So I would, yes, I agree with that. The whole thing is that going off I covered the charter, but I think, as you know, that when the.
Are we going to rehash?
I don't think so.
I'll be honest with you, there's a lot of information that we have gathered, and a lot of people have talked about it, and you have.
Let me.
But the problem is sometimes the elaboration gets.
All right, let me ask you this much. Do we discuss, there's a process when these recalls come up that it has to be sent to the select board. So who's going to get it sent to? Me, right? I don't think that has been brought up yet in regards to
It was
The petition's being brought up, right?
Right.
So, in regards to the recalls and voting, you know, it says right here, let me see if I can skip over the affidavit part.
What document are you referring to?
Page 16 of the town charter.
Town charter.
Town charter 8-1-2. The blank shall be issued to the town clerk with his or her signature and official seal attached thereto. They shall be dated, shall be addressed to the selectmen, and shall contain the names of all persons to whom they are issued. The name of the person whose recall is sought, the grounds of recall as stated in the affidavit, and shall demand an election in successor of office.
I believe we've satisfied that. The town clerk has processed it properly there. There's nothing new there, Eric. We are same material. So I'll be honest with you. Where I'm looking right now is that because there's so many different activities associated with this, a lot of information came to us this morning, and we haven't had a time to really, truly digest it. And we really need to do that. And to be fair, we need to have the signature discussion, and that's where your part comes in. Unfortunately, we are not going to make friends out there and make some enemies and stuff like that, but we want to be as fair and open as we possibly can. So I am tending to say, we're going to move forward with this. We're not going to make a decision on it. I will ask the other two registrars their positions on this, and then we'll meet again on the 29th to discuss the signatures. And again, we'll do line-by-line activities on that. But we just want to be everybody to be open and as best we can, you know, good neighbors to each. You know, we recognize that everybody, certain lives are affected by this. We recognize that. And it's been said in other venues.
It's not certain, it's a lot of lives, because.
It's true. But
because the whole thing is that.
It's a process.
Even though people may look at it as just me being impacted, there are thousands of people in this town that may be impacted because of what
That's true.
Sean and Lara have done here, because
Again,
they don't like.
We're not getting into that debate at all. I agree 100% with that. We're trying to keep this as formal as we can in the discussion. I understand.
I'm not going to, listen, Mr. Chair, I'm not trying to suck up any more time. I know we've been here long enough. You two, Mr. Riley, myself, the people here are not getting paid for this, all right? As opposed to the attorneys and all that, everything, the town clerk and the staff and the team, right? I get that, all right? Here's what I just want to tell you. So this right here, I want to submit it for evidence. This is last year's, what was submitted to me when the recall for last year started, all right? It's signed, stamped, town seal on it, and date and time on it, all right? Right here. This is this year's one, all right? There is no time stamp or date stamp on it. It's not signed, nor is there a town seal on it, okay? So if you go in the charter in regards to the process where it's supposed to go to the select board, this, as well as some other documents, but I don't think you need those, is what's sent to the select board in the thing. So my opinion is that if you review this in the process in regards to the charter, and what was done before and what was not done this time around, in my opinion, you should just discount this whole recall,
If you wish to
okay?
add that as evidence, or.
I would kindly appreciate that.
Definitely, and we understand your position, yes.
And Mr. Chair, if I could, Mr. Kelly did reserve time to present an overview of his legal arguments, and so, I understand we've all been here a long time, but I just wanted to make clear he had reserved that time to make any additional arguments.
We did provide him the opportunity.
Yes,
so.
yes.
All right. Dave O'Reilly and Dave Kohler, do you have any insight, or my position right now is to say we need to digest a lot of this information and then look at the signature activity coming forward next week, and then make our determination of how we want to proceed. But how do you guys feel?
Yeah, I'd say absolutely. At this point, I got to digest a lot of this. that came in. I'd love to look at the signatures that you're talking about and help validate that. So sadly, I agree moving forward.
Mr. O'Reilly? He's looking for that mute button. No, we got to go look for him. He's not in the picture anymore.
Mute him a little bit.
Can you hear me?
Oh, now we can hear you.
Okay, thank you. I agree with you guys. I definitely think that we've learned a lot today. There's a lot to go over in our own minds and together. And I think that we'll move forward. And the signatures are really going to be the most telling part of this whole case.
Sounds like a great idea, the direction. So I'll make a motion that we recess this meeting until, this hearing, this informal hearing, until the 29th of May at 9 a.m. And it's 1:43. Do I have a second?
And here, in
And
this
here,
room.
and here in this room.
Yeah, I second that.
Second.
Second here.
Okay. Walter Sterling, aye.
Dave Kohler, aye.
Dave O'Reilly, aye.
Thank you.